That-
My lord, may I leave to mention one matter? My lord, in this matter, my lord, 10(4) of the Highways Act order was passed, but they are not implementing. My lord, urgency is this to enter my egress and egress at block. So it was appeared in the list. My lord,
Is it so urgent, sir?
my lord, otherwise my entrance is blocked. Long pending matter order was.
It has been if he
January
it
2000.
has been blocked for a considerable length of time.
25 long battery, my lord. I have passed an order on 10(4) to January, my lord.
No,
Kindly
sir.
take
I am not convinced.
My lord, may I be permitted to mention on urgent basis one matter? The school is situated adjoining to the land of the irrigation department. My lord, the local hooligans, my lord, what has happened? Local hooligans, my lord, put a bamboo fencing across the, my lord, that particular irrigation land, for which the students of the kindergarten school, small kids, are not able to access to this. Kindly see the photograph how they are, my lord, climbing the fencing, and beneath the fencing, my lord, they are passing through the school, my lord. This is, and my lord, during the vacation, my lord, they have planned to, my lord, install a club, my lord, establish a club and stalls over the government land, my lord.
So what do you want?
For removal, my lord, we have on several times went to the office of the irrigation department to seek removal of the bamboo fencing raised by the local. We are the owners of the school, running the school. We cannot, my lord, go into.
So what the REIT court will do, sir?
Ask them to, my lord, the irrigation department to remove it. It is because of irrigation department's land.
Under which provision of law?
Under the West Bengal, my lord, Unauthorized Occupants Act. West Bengal Eviction of Unauthorized Occupants Act, 1962. Tomorrow, my lord. Tomorrow, my lord.
Tomorrow not possible.
My lord, tomorrow, my lord. Otherwise, it is very difficult. But any accident would occur, my lord. Kindergarten school, my lord.
24th September. 24th.
Tomorrow, my lord.
25th September.
My lord, may I have your lordship's, my lord, kind leave, my lord, to file and move this application, my lord, prior to the vacation, my lord. What happened, my lord? Under section 17A, my lord, a particular plot of land has been declared, my lord, as water body. My lord, although my contention is that it is not a water body. So I challenged, my lord, that order, my lord, in appeal. Now, my lord, what happened? The appeal court is not hearing the matter, he is keeping it pending. And, my lord, the authority concerned has issued notice, my lord, for taking possession. My lord, this is my lord. I say, my lord, that the appeal should be heard, my lord, and till such time, my lord, the authority concerned should stay their hands, my lord. My lord, or else, my lord, my appeal will become.
Under which provision of law you filed the appeal?
My lord, under West Bengal Fisheries Act, section 18, my lord, I filed an appeal, my lord. My lord, they have passed an order, my lord.
Move before the vacation bench if it's so desired.
Lord,
No, I don't have any time, sir.
Any day, my lord.
Only few days left.
Any day subject to your lordship convenience.
Any day, all days are already full.
Kindly, my lord, kindly consider, my lord. My lord, they will take my possession, my lord. My appeal will become infractual.
September 25.
Grateful.
My lord,
Your lordship, if I may be, I'm seek leave, your lordship, if this would be taken up before the vacation. There has been an order of resumption. Your lordship had previously heard the matter and passed an order, your lordship, say cancelling the resumption that was previously done, and had stated that only to comment on the comprehensive plan that was submitted. They have rejected the comprehensive plan and held that they are duty bound for the same reasons as previously your lordship has set aside, to that they will resume the land, and they have said that you give us show cause within 7 days and we'll resume the land. What they plan to do, your lordship, is during the puja vacations, before the vacation bench starts, they, as soon as we give the reply, they will resume the land. And they have, your lordship,
let them resume.
Lordship, they have even modified your lordship's order. Your lordship, it's your lordship has
No,
previously
not so
set aside this resumption.
Yes.
Your lordship, it's very urgent, your lordship, if it could be taken up, your lordship.
No, sir.
Your lordship, any day, your lordship.
Not
your
possible,
lordship, your lordship has himself set aside this or
not convinced,
resumption.
sir. Yes.
Your lordship, just for a stay, your lordship, in the meantime.
my lord, may I take your lordship's kind leave to move this writ petition, my lord, as listed motion, my lord. My lord, the urgency is this, my lord. My lord, I purchased a property in the year 1950, my lord. My lord, West Bengal Land Reforms Act came, my lord, in the year 1955, my lord. My lord, in the meantime, my lord, they want to give retrospective effect, my lord. They are just, my lord, the SDO has passed an order in, my lord, that the land is vested, my lord. And my lord, in the meantime, they have given a notice, and the police authorities came, my lord, to take my possession, my lord, and to demolish the, my lord, to demolish, my lord, kindly, my lord.
Sorry. Not so
My lord,
urgent.
Under grave urgency, I am mentioning, my lord, kindly, my lord.
ফেরত দিন ওনাকে।
My lord.
Upon notice, I am mentioning this before your lordship, inclusion in the list of good format.
my lord, any day, my lord,
To
before
mention.
the
Not possible,
vacation,
sir,
my lord,
not
kind
My lord's kind leave to mention.
Otherwise, my
What
lord, the
inclusion?
land, my
Sorry?
property
In the
is
list.
demolished, my lord.
Please, inclusion in the list.
Yes.
I'm grateful.
Yes, sir.
What was urgent motion, my lord, the petitioners, but in response to advertisement, made application for a grant of plot of land. Is the Broadband Development Authority and the Sachi Development joint venture, my lord. I applied, I paid the entire concession money, and the lands are sold to be Shali since converted to, my lord, for converting for Bastu land. Well, after payment of entire concession of 45 lakhs, now they are saying one of the plots have been still remain as Sali. They have not rejected. They have said until the conversion of the plot, initially they have showed that the Sali plots of land. They said every plot will be converted to the Bastu land.
Who said that?
Badwan Development Authority.
Badwan Development.
Entire concession now say until the conversion of the plot of land to one of the plots, two plots are sanctioned. One plot has been remained Shali, Pukur. But the documents supplied to us, my lord, that shown that the plots of land is Shali, which converted to, my lord, Bastu land. Entire concession, because of the case.
What is your grievance then?
My grievance, I made a representation. I said that you have shown me the documents displaying the land as Shali converted to Vastu. Now there you are saying that it remains still.
No, for that, what suffering you have got?
If your lordship kindly direct the authority to consider because they have not rejected. They have said until the conversion. That is the concession representation, my lord. That is
Unatown, 25th September.
Deeply obliged.
Unatown, 25th September.
Deeply obliged. Deeply obliged.
বাবার একটা বাড়ি দিন উনি ওনার জমিটা
মাইক্রোফোনটা অ্যাডজাস্ট করে নিন।
ওনার জমিটা আর ডিপার্টমেন্ট ওনার এনওসি ছাড়া অন্য লোককে কিভাবে দিয়ে দেয় সেই ব্যাপারে ভাই বোন মানে ওনার সঙ্গে থাকতেন আর কিভাবে দিয়ে দেয় সেই ব্যাপারে 3 তারিখে একটা কেস করেছিলাম, এই 3 তারিখ। সেটা আমাকে 11 তারিখ ডেট দেওয়া, মানে প্রপোজ ডেট করা হয়েছিল। তারপর আমার মানিটারি কন্ডিশন খুব খারাপ স্যার, আমি চিঠি নিয়ে এসেছি, যদি একটু তাড়াতাড়ি হিয়ারিং ডেটটা দেন আর কি কাইন্ডলি। খুবই খারাপ।
কি সমস্যা কি হয়েছে?
বাড়িটা অন্য লোক, আমি বাড়িটা অন্য লোক বাস করে, এটা যদি ভ্যাকেট হতো তাহলে আমি ভাড়া দিয়ে আমার চলতো আর কি, আমি চালাতে পারছি না সংসার।
এত তাড়াতাড়ি কি আছে? আপনি কোর্ট খোলার পরে মেনশন করুন, আমি শুনি।
স্যার একটু চিঠিটা যদি নেন
না। ইয়েস, কল দি লিস্ট।
কোর্ট খোলার পর
কোর্ট খোলার পরে এসে মেনশন করুন, আমি দেখব।
মেনশন বলতে হ্যাঁ 26 মেনশন বলতে স্যার আমি ঠিক জানি। ইন পার্সন করছি স্যার।
ইন পার্সন করছি, ঠিক আছে।
26/10 পর এইভাবেই এসে বলবো।
আচ্ছা 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 ঠিক আছে।
Pursuant to Lordship's direction, my lord, we approached the learned government pleader's office, my lord. They refused, my lord, and they intimated that Mr. Tapon Kumar Mukherjee, senior advocate, and
Lordship,
Gita Roy is appearing.
Lordship,
Why
Mr.
the office of the learned GP is refusing to accept the letter?
No, it was late in the day and 3:30. So they were under the apprehension that they will fail to contact, my lord.
Lordship,
You ought to have made an endorsement to that effect.
My lord,
Received with such and such rider.
my lord, we contacted them, my lord, through WhatsApp and mail, my lord.
Where is Mr. Mukherjee?
Lordship, Mr. Mukherjee is out of station due to his personal difficulty till Wednesday. Kindly fixed it on Thursday, Lordship. He will come. I've been instructed to take time on his.
What is the urgency, Mr. Sen?
My lord, the proceedings under 64 Act has been initiated, my lord. We came before this honorable court, my lord. Honorable court directed, my lord, that a inspection be held. My lord, inspection was held, report was given, but no sketch map was supplied to us. My lord, again we
By which order you are impugned?
My lord, page 175, my lord, will kindly consider the order passed by this honorable court, my lord, on the earlier occasion, my lord.
175.
175. The malad, the hearing was to take place, malad, but the same was set aside. Two parallel proceedings in respect of the same land, one under the 64 Act and one under the 62 Act was levied, malad. The Honorable Court has been pleased to record my submission and set aside the order so far as the passed on the earlier occasion, as the sketch map was not given, although the report was supplied to me, malad. Subsequently, malad, the malad will kindly then come to page 181, malad. We were given liberty to give a reply to the after service of the sketch map. We have given reply, and on the same date, malad, we had asked for the copies of the malad demarcation map, malad. Malad, that has not been supplied. Subsequently, malad, page 200, malad will find the order passed by the in reply to our query, malad, order has been passed that it has been transferred to another department. Our query has been transferred in view of the malad, Right to Information Act, malad. Malad, we humbly pray, malad, the demarcation map be given and hearing be done. This is our short pair, malad. Malad, today at 12.
Mr. Mukherjee is out of station, he's saying.
Malad, 12 at 12, malad, today, malad, the hearing state, malad. In that event, malad, we'll pray for time before the authority, malad. And
Pray for time.
malad, that may be recorded, malad.
Yes, I am recording that.
My lord, I appear for the respondent.
Petitioner late by Mr. Vishnu Chaudhary. He engaged court number 37.
I am
in
appealing for the
short pass
state
over your
respondent.
Pass over. Item number 2, Shatabdi Das, Vishwajit Kole.
My lord, in item number 2, Mr. Banerjee appears, my lord. He's on his way, my lord. My lord,
I'll take up, I'll start.
Mr. Owen Banerjee.
I'll start or I will wait.
My lord. Let the learned senior counsel start.
The short point for consideration.
Give me a second, sir. Yes, Mr. Bhattacharya.
Kindly turn to page 94, the order of the High Court.
Page number
94. The grievance of the writ petitioner is that an application for renewal of an existing mining lease allegedly made 6 months prior to the expiry of the tenure has not been taken up for consideration, and the petitioner is continuing the mining under Rule 12(6) of the Minor Rules 2002. Then there is no need to go into dispute raised by the state as to whether the application for renewal is made at the appropriate time. Since such application for renewal has been made, the district magistrate should dispose of the relevant application within 4 weeks of the receipt of a copy of this order. Therefore, the direction was, this part I am not troubling, my lord, that from the 4 weeks from the date of the order, that's December 2022, 2015, it should have been disposed of without right accrued in terms of the old rules. The district magistrate, however, my lord, did not consider that and kept it pending, and ultimately dismisses it on the ground. The new rules are there.
No, district magistrate Bankura should dispose of the relevant within 4 weeks of the receipt of the copy of this order.
Yes.
So that was kept pending.
That was kept pending. But December 2015, 4 weeks would come to January 2016.
January 21, 2026. Then what happened?
Then we will kindly come to Milord, page 97.
So when the order was not complied with, you have not approached this court in contempt.
I approached the honorable court. Milord felt that since there is appellate forum, we would preferred appeal. I had preferred appeal, then review. Now all rejection. Now I am before your lordship, Milord, from that order. Milord, kindly come to page 161, the impugned order now before your lordship.
You said page number 97, sir?
97 was the order which was passed by the district magistrate, allegedly after the direction of the Honorable High Court by its order dated 22nd December 2015. Kindly see the hearing was held on 21st October 2016, much beyond 4 weeks from 22nd December 2015.
21/10/2016.
Therefore, the GM concern at the first instance, in fact, Lord, gone beyond the scope of the order of the High Court, and by that time they say that the new rules are there, therefore I can do this.
No, what order has been passed in by this order? Page number 97?
Yes, may I place this? I have gone through the West Bengal Minor Mineral Rules 2016 as well as West Bengal Minor Action Rules 2016, whereby it appears that
Minor Mineral Rules. Yes, sir.
Rule 62, from Rule 62 of the West Bengal Minor Mineral Concession Rules, that the West Bengal 2000 rule has been repealed. Therefore, Milord, he in fact, Milord, considers in terms of the new rules. Rule 62, Rule 61, Lordship had the occasion, Milord, to deal with that. I am not troubling, my Lord, because the last occasion it was shown whether the right accrues under the old rules, Milord, should be implemented. Therefore, he says, I have also gone through the order
dated 26th February 2012, Honorable Supreme Court, in special leave petition so and so. Then he says that the entire exercise to bring the existing sand mines under the new rules, therefore he is considering under the new rules, shall be completed within a period of 3 months. And this judgment which he has relied upon, I will cite that, with due respect, has no manner applications over this case is concerned. Therefore, he said that it should be on e-auction. Now, kindly turn to the order impugned before your lordship after various stages at page 161. But this is the original order which was reviewed and review was dismissed. But I have to challenge this order. Therefore, I am before lordship challenging this order of appellate authority. Appeal was disposed of under Rule 51 of the Minor Mineral Rules 2016.
Yes, sir. The order dated 17-2.
Order dated 17-2.
Yes.
Kindly come to me in the third paragraph. Deputy DLLRO Bakura, on behalf of the respondent, submit that lease renewal petition was not considered in due time due to non-submission of environment clearance. Is that in view of the Honorable Supreme Court ruling in 2013, environment clearance certificate became mandatory for granting minor lease. An advocate for the appellant stresses upon Rule 62(2) of the West Bengal Minor Mineral Concession.
You are reading which portion, sir?
The next page. I don't know whether pagination would tell you or not.
163 over 3.
Kamata ঠিক করোনি। 163.
Paragraph number 5.
No, kindly turn to next page. Malodi, looking at page 163. This will be
you referred 161.
Yes.
It continued up to 163.
Kindly come to this continued to 163.
But I'll skip the middle pages.
Yes.
Middle page.
Middle page. On scrutinizing all the relevant documents. 163.
That is at page number 162. Very good.
Got it. On scrutinizing all.
Yes, I got it.
All the relevant documents and materials on record found that the long-term mining lease deed of the appellant was registered on such and such for 5 years. Thereafter, the said lease of the appellant is expired in 2015. However, it appears that there is no provision for extension of renewal of lease after expiry of lease agreement in terms of Minor Mineral Rules 2016. Besides, in terms of Rule 61 of the West Bengal Minor Mineral Concession Rules, all applications for mining lease of the minor minerals, including the reclassified minor minerals BS1, received prior to the giving effect to these rules, irrespective of its duration of pendency, shall become ineligible, provided that if the application has been issued to grant order of intent or any other government order requiring the alteration of application. This is the ground. I say that you cannot take this ground because the High Court's mandate was you have to consider it within 4 weeks from the date of the order.
When the coordinate bench passed a favorable order, at that material time, 2016 rule was implemented.
No.
So that is why the High Court was, the coordinate bench of the High Court was not contemplating the 2016 rule will come.
That's my point. My point is
Sir, suppose I passed up an order. I do not know from tomorrow it will change. So in the event the rules of 2016 change, so what the author will do?
My point is different. The High Court said you consider within 4 weeks. New rules did not come within 4 weeks of the passing of the order.
Be there as it may, for some reason or other, rules that cannot be taken up.
Yes. Therefore,
now, in the meantime, on the day of consideration, the rules have been changed. Rule 61 is saying that if LOI was not issued or such and such is not issued, you will not be your application lapses.
I am not really contesting that proposition. My point is my right crystallized with the order of the High Court.
I understand, sir, but in the event, and for the sake of argument, if the court accepts that your contention is true, but when the coordinate bench passed the order, the coordinate bench was not in contemplation that 2016 rule will come.
Rightly so. But But my lord,
Where's the scope on behalf of the authority?
when the coordinate bench will had fixed a time schedule, you are bound to consider within the time schedule. If you consider within the time schedule, then I am entitled.
No,
to
if he has failed to observe the time schedule, you have the other option. But how can I direct the authority to consider under the old rules when the 2012 rules has been repealed?
Lord, the repeal comes, say, on X date. Lord, my right accrues, Lord, on Y date. If you keep it pending,
Sir, Act says your right would be protected if the grant order is passed or LOI was issued. You do not possess any grant order, you do not any LOI, so you don't have any case. Sorry.
Lord, my point is kindly consider this aspect in that sense.
No, sir, I will not.
That will affect my case. That will affect my case. I want because in addition with that, I'll raise 2 points.
What is this matter?
Yes.
In this matter?
Next matter, the same matter.
Similar
When the two losses pass any order, that will prejudice my interest. I'll argue on 2 points. Kindly bear in
I do
mind.
not know your case.
Kindly take that next matter before.
Let me pass my order.
Well, that will prejudice my case.
What he says.
No, Mr. I cannot give in Mr. Bhattacharya's clients any favor on account of your case.
No,
Sir.
favor on my
Let
case.
me allow.
Kindly bear me for a moment. Kindly bear me for a moment. Kindly bear me, my lord. That is very serious. Whether at all 2016 rules can be invoked or not. But I'll argue on this point because there's a basic difference. Gazette notification and to give effect of these notifications. I'll do Supreme Court judgments as well as lawsuits own court judgments. Here, first let them show that there's a further notification and that documents are available in the government counter for the public.
No, Mr. Banerjee, let me pass the order first.
But that will not any.
If Mr. Banerjee's point succeeds, then I get the benefit. I don't know if it succeeds or not, but
That I will not allow.
that's the point.
I'll argue this point.
Ashwin.
My lord, whatever argument, case is more or less same facts. Whatever argument has been advanced by Mr. Bhattacharya, I don't like to repeat to embarrass your lordships and disturb your lordships. My point is twofold. Number one, my lord, that obligation on the part of the authority regarding publication of notifications. It is not my word. I am borrowing the word from the Supreme Court of the judgment. What is the date to be taken care of? Now, just by publishing a gazette notification will not do. They'll have to place before their counter for public availability. That is very vital aspect. Not only Supreme Court, but our High Court also decided on this point. So, my lord, fact more or less same. So, just by repeating, no purpose will be served. I'll take 2 points. Number one, High Court initially mandatory order was passed, very rightly passed. Anyway, why under what circumstance that was passed, as explained.
Where is the order? What is that order?
I am coming, and let me. And secondly, my lord, regarding that notifications, that when it was published, when it was available to the public to know. Now, my lord, I'll just cite to judgment, my lord. It's very interesting because unnecessary by laying the argument on question of fact is immaterial. First, I will cite 1998 All India Reporter 1998 Supreme Court.
PIR 1988, 1998.
1998 Supreme Court. Oh, page 668, paragraph 12-13. ठीक है. I'm making half a minute time. 19 Supreme Court. नहीं पता. ठीक है. Here regarding that customs, my lord, the authority illegally realized the money that was challenged and went up to the Supreme Court. Supreme Court in his wisdom thought it fit. No, this is not correct realizations because they must show when this practically it was notified and when it was available to the public, because my lord knows better than me, my lord. In News Secretariat, my lord, the ground floor, there is a counter for public government publications. Kindly come to paragraph 12-13. Fact is like this, my lord, that authority wanted to realize the money based on the notifications. Have you got it, my lord? Have you got it, my lord?
Yes.
We hold that a central excise notification can be said to have been published except when it is provided otherwise. When it is so issued as to make it known to the public, it would be a proper publications. If it is published in such a manner, that person can, if they are so interested, acquaint themselves with its contents. If publication is through a gazette, then mere printing of it in the gazette would not be enough unless the gazette containing the notification is made available to the public. The notification can be said to have been duly published. As the view taken by the tribunal is correct and such and such and such. So, my lord, that goes to the root of the case. My lord, the problem is this, my lord, sometimes before it is give effect and it is available to the government publication, my lord, some publishers, they started publishing this. I must finally confess, it is not a credit or discredit. When I became the GP of the first GP of this government, I issued an order that no, unless the government is published this and it is available to the public, you cannot, because everywhere they are saying we are not concerned. We have just somehow we are collected and we are publishing. That will not do. It is duty on the authority to show. Let them produce this document. Yes, that they have taken the step and it was available to the public in the counter. And that is also decided by our High Court. I'll come to that. So this is the case where a customs duty was imposed wrongly in this way, based on a gazette notification. Supreme Court says mere notification, gazette notification is not enough.
Sir, carriage of proceeding is upon you to produce that on the relevant day it was not.
No, that's why I said no, it is not. No, my lord, this is not the obligation on the part of. That's why Supreme Court says it is not the obligation. It is the duty of the authority to produce.
Place some document that on the day of publication it was not so published.
It is there.
It is in the book. It has been stated.
Kindly see what is the section. Everywhere it is said. it shall come into
Notification
force.
such and such, dated 20.
No, it shall come into force from the date of publication in the official gazette.
You are reading which portion, sir?
Well, definitely, this is it that
1-3, 1-3,
Yes,
1-3.
1-3.
Just above that, the notification number is given
Yes,
29 July
yes,
2016.
everything is there, no problem. That will not do, Supreme Court says. That will not do. That is the Supreme Court verdict, my lord. It's not my statement. So that will not do. More applications on the
Sir Banerjee, try to visualize. You are the lead petitioner.
maybe.
Carriage of proceeding is upon you. You are to show that on 29 July 2016, you place some document that it was not available.
My lord,
It was not published.
there is a
Thereafter, I shall ask
no,
them.
there is a basic and fundamental difference for this. One is obligation on the part of the petitioner to what extent, to what effect. Another obligation part of the government or the authority to produce.
Very
Here,
good, sir.
Supreme Court says
I want to be much more lenient. What is the pleading to that effect?
but
That
that's
it was not.
really question of law, no question of pleading.
Sir,
Question of law.
it is a read petition, sir. You are a wise man. I know.
No,
Sir,
my lord,
if it be a civil proceeding, there is no need to produce evidence. Pleadings are sufficient, and unless there is a pleading, you will not be permitted to give evidence. But you know, in a read petition, you have to plead and you have to give evidence. What is the pleading to that effect?
now
That it was
kindly
not
appreciate one aspect. Had it been a case before the Supreme Court and our High Court, the plea was taken, not taken, plea was not taken. Justice Roy, my lord, deliver the judgment based on that judgment. I'll place the judgment. I'll not run away.
very good. Then come after vacation.
Let them produce this, my lord. It's affidavit.
Why should I? Sir, carriage of proceeding is upon you. Please take your seat. Carriage of proceeding is upon you. Where is your pleading that when the order was passed, the notification was not published? First, satisfy that.
My lord, then again I say, my lord, the similar circumstances, another division bench of Justice Banerjee. I started my argument on behalf of the corporations. The petitioner, 4 days consecutive hearing. That plea was not taken. The division bench asked me, Mr. Banerjee, it is your duty to satisfy the court that you have done your discharge your duty properly. You are a statutory body. Whether petitioner is saying it is court's queries. Now you will have to answer whether that was properly.
No, it is not court's query. Court's query is upon you. You are the read petitioner. Carriage of proceeding is upon you.
The division bench
Where
told
is
me.
your pleading to that effect that on
Division
the
bench
day of
told me, I
passing the
took that plea.
order by the district magistrate or on the day of passing by the order of the divisional manager, there was no gazette publication.
Kindly appreciate. I took that plea before the division bench. I took that plea. My lord is perfectly right. I took the where is that plea? Mr. Division bench nothing doing because statutory authority, you will have to produce this document at 12 that has been done.
No,
that
sir.
you can't do.
No, sir. This submission, I'm not convinced, sir. Will you may I pass the order?
No, my lord, another judgment I will put because when my lord is passed the order, my lord have to put. Then just do one thing. Very well. I'll try to bring all these things, my lord. Take it after vacation, no problem.
Very good.
Because
As
this
per
board
request,
schedule-
Mr. As per request by me.
Hope, not please me.
Well, at the satisfied.
As you lord, of course. Unless I satisfy why my lord is passed order in my favor. এই বইটা দিয়ে দাও।
বইটা ফেরত দিও। বলেন বাবু, বলেন বাবু। Yes.
Item number 4. Item number 4. I will respondent. I will
for the petition.
In this matter, my
You
lord,
are-
there is
Lord,
direction
I tell you,
copy to the KMC, ma'am.
Lord, I appear for the respondent number 20, the Kolkata Municipal Corporation.
I'm sorry.
No, my lord, only one thing. But I don't think the Kolkata Municipal Corporation is at all a necessary party. My lord, kindly, Lordship hears it, kindly expunge me. Because I tell you, Lordship, accent. I'll tell
You
you,
are appearing on behalf of whom, sir?
Kolkata Municipal Corporation. Now, my lord, the impugned order passed by the Wetlands Authority. My lord, I'll just, before, I'm sorry, I know he's the petitioner. Why I say I'm not taking, I don't have any role. But kindly takes only one line. Then after that, if your Lordship feels, I'll be here. Kindly takes page 53, the last part of the impugned order.
Give me a second then.
Lordship. I'm not on the merits. I just know that whether I should be here or not at all. আমি দেখি দিচ্ছি কোথায় আছে পেয়ে গেছি
Page number, which one you are referring,
53,
sir?
53, my lord, the last page. Not the last page, page 53.
Yes.
My lord, kindly see the decisions of the EKWMA, that is East Kolkata Wetland Management Authority. Lordship has got that in the middle. Decision of the EKWMA.
Yes.
Now, my lord, 1, 2, 3, 4, 5, 6, 7. Seventh, my lord, seventh line from there, it starts with wetlands. Then, therefore, the respondent numbers 10 to 13, such and such, are hereby directed to demolish the unauthorized building construction and restore the subject land's previous status at their own cost within a period of such and such, with the issue of this reasoned order under section 11. Then, in case of default by them, the EKWMA shall direct the KMC to undertake the demolition order. So, first of all, the private respondents will demolish. If they do not, then the KMWMA shall direct the us to demolish. My lord, at this stage, my lord, this situation of me coming in does not arise at all, subject to your lordship's consideration.
So the order has been passed by your officer.
No, EKWMA is East Kolkata Management Wetlands Authority, state government authority. They say the private
No, the order under challenge has been passed by the chief technical officer.
EKWMA, Department of Environment, West Bengal government. They say that the private respondents are to demolish. If they fail to demolish, then this authority will direct, then at this stage, the Kolkata Municipal Corporation to demolish. So, my resource submission, at present, I am not at all. If let them first not demolish, let them direct us, then only we come in.
Section 11.
My lord, if your lordship wants, I will be here. But
My lord, same word.
Kolkata Wetland Management Authority was not the party.
Yes.
Their party. I do not know where I come.
Yes.
So East Kolkata Management
My lord,
Authority.
this order was passed by the East Kolkata Wetland Management Authority.
Let me complete. I have not completed.
Yes, sorry.
So East Kolkata Management Authority directs the private respondents to demolish. In case of
East Kolkata Wetland Management Authority is a functionary of the government.
yes,
Instrumentally of the state.
Department of the Environment. So they say private respondents are to demolish. In case of their failure, then they will direct us. So situation is not
In
direct.
anticipation.
In anticipation.
Municipal corporation was directed. That was not demolished by the private respondent. Thereafter, my lord, municipal corporation was directed.
In my limited understanding, I made this submission.
It has been passed. The order has been passed.
Yes, my lord.
Let me hear.
Demolition order
So
was
if
passed.
this goes, it will automatically go.
My lord, municipal corporation was directed to demolish.
Very good. Place your
Not
case.
demolished, my lord.
That order I have not served, ma'am.
Very good. Forget about this order. You place your
Very
case
well,
first.
very well.
My lord, in this matter, I led by Mr. Kolol Bashar. He is on his legs, my lord, court number 7.
So why are you wasting time, sir?
তাহলে পরে করবো।
Not today. এটা ফেরত দিয়ে দিন।
এটাতেই হবে সান না
Make,
একই তো
in case of any difficulty, make your submission at the first instance.
My lord, then kindly fix my lord on Friday, my lord.
এই ফ্রাইডে
Friday. Friday. My lord,
Last working, I'm sorry.
Thursday, my lord.
Not today only.
Only not.
ফ্রাইডে
Only not.
Or I take up at 2 p.m.
My lord.
which will be convenient.
My lord, tomorrow, my lord. Kindly take it up tomorrow.
Tomorrow, not today করবো।
ওই কাগজটা।
ওগুলো ওকে ফেরত দিয়ে দিন কাগজটা।
তো দিয়ে দিয়েছে বললো
This time the court's time is precious and this time is equally precious. So kindly cooperate, sir. Otherwise, 4-5 not today only.
In item number 6, Lordship, I beg to appear on behalf of the petitioner.
But I'm for the state respondent, my lord, I got the report.
In earlier occasion, Mr. Dev was not feeling well, so that's why he asked me that if not present, my lord, I may ask for time. But if someone is represented, my lord, can you take up my matter? This matter is pertaining to a record of rights, Lordship. The petitioner's record of rights was there, and subsequently it has been turned down by the correspondent authorities without any rhymes and reason.
Give me a second, sir.
Lordship.
Yes. What is your case?
Lordship, kindly come to page number 16, Lordship.
60?
16, Lordship.
Page number 16.
16, Lordship. It's a record of rights which is, Lordship, issued in 2099, Lordship, 99, in the year of 99, Lordship. So this property is recorded in the name of Debottar Shishi Ma Chundi Thakurani, and the petitioner is one of the Sebai. If Lordships come to the left portion, Lordship, there is one tag number indicated 962/1422 that is recorded at bus 2. That is transferred.
962 1422.
1422. That is the subject matter of this writ application, Lordship.
Yes.
That is recorded at bus 2. Now, Lordship, that was the RS record, and subsequently, Lordship, page 2 is also that CS record, Lordship, that the Khotian is transferred from the document, and the very next page, Lordship, kindly come to the in the left side of the tag number, Lordship, will find that 1422 and 9/962 is there, Lordship. This tag number is in existence, Lordship. Now, subsequently,
9/962/142.
Yes, your Lordship.
Then oi ghor such and such. Yes.
Now, Lordship, kindly come to page number 19, Lordship. That subsequently the petitioner made an RTI application where the petitioner has stated that the record of rights of that particular property has been converted into Khotian number 1. Now, this RTI application is pending. They have not bothered to answer to this RTI query, Lordship. That was made on 30/3/2023. Now, Lordship.
No, what is your what information you provide me?
Well, Lordship, I search in the record of rights. I find that the property is now not showing under the Khotian as it transferred from the record of rights. It is showing that the property is in Khotian number 1. I made the representation, Lordship, in this regard. If your Lordship come to page number 21, I made the representation to the BLLRO. That was 18/1/2028. May I read out the page number 21, Annexure P5, Lordship.
21 or 22?
Yes, your Lordship.
21 or 22?
21, Lordship. Page number 21. To the BLLRO, Amta 2, Joypur, Howrah. That মাননীয় মহাশয়, আমার নাম সাচান সাজ ও গ্রামের সাচান সাজ মৌজার 1 নম্বর খতিয়ানভুক্ত জয়চন্ডী ঠাকুর সেবাই ওই খতিয়ানে স্থিত আমার একটি বাস্তু আছে। ওই বাস্তু সাচান সাজ এর কাছে উক্ত খতিয়ানে আছে এবং উক্ত দাগ নাম্বার অস্তিত্ব আছে। প্রমাণিক 2002 সালে আমি যে কম্পিউটার পর্চা বাইর করেছিলাম তাতে ওই দাগের অস্তিত্ব আছে, কিন্তু বর্তমানে দেখছি উক্ত খতিয়ানে ওই দাগটি উল্লেখ নাই। সেহেতু আপনার কাছে আমার বিনীত নিবেদন এই যে এই দাগটির খতিয়ানে রিএন্টার করিবার যথোপযুক্ত ব্যবস্থা লইয়া আমাকে বিশেষভাবে বাধিত করিবেন। দ্যাট অ্যাপ্লিকেশন হ্যাজ বিন মেড in the year of 2022, Lordship. Then after, Lordship, kindly come to page number 22 that the detailed representation has been made by indicating all the aspects, Lordship, and the allegations against the BLLRO. It was copied to the ADM, LRO, and to the Secretary of the Land and Land Reforms, Refugee Relief and Rehabilitation Department.
Why before this court go before the tribunal?
Lordship, that is not my subject matter. My subject matter is that, Lordship, I made an allegation that they have, if the, Lordship, is there anything that this property should be converted into Khotian number 1, Lordship, there must be a correspondence. But without
there must be,
Lordship, there must be a correspondence that for reason this property has now belong to Khotian number 1. That has not been provided to us, Lordship. I made the RTI application. They are not.
Either you have to prefer an appeal,
Lordship,
challenging the wrong entry. Or if you have to approach the tribunal, why before this court?
They are silent on that ground.
I will allow you.
They are silent on that all the aspect, Lordship. I made the
So what is your prayer? The prayer in the
my prayer is, Lordship, to that the computer data showing that LR record of right in the year of 2002, Lordship, my name was there. But subsequently, the present LR record is showing that my name is not there, Lordship. It be restored by the concerned department, Lordship.
Restored then. Very good. Yes.
Because page 19, my lord, the application is premature, my lord. Accordingly, my lord, we have made an application under the RTI Act, my lord, as per section 6, my lord. My lord, there is a provision of appeal, my lord, as per first appeal, my lord, as per section 19(1), and also the second appeal, my lord, as per section 19(3), my lord. Before availing this opportunity, my lord, he has filed this application before this honorable court, my lord. That is the premature.
Let it be considered in accordance with law.
On the other hand, my lord,
RTI is a different aspect.
page 17, my lord. My learned friend make the submission, my lord, that is the CS record.
Yes.
CS record lying in the office of the, my lord, district magistrate in the year 1955, my lord. At the bottom, my lord, date, my lord, 7/10/88, my lord. How is it possible, my lord?
This is attestation by someone.
আপনি যখন বলেছেন আমি তো কিছু বলিনি দাদা, আমাকে বলতে হবে। At the bottom, my lord. See the date, my lord, 7/10/88. And the record lying in the office of the district magistrate, my lord. And the next page, my lord, 18, my lord. That is the RS record, my lord. Record lying in the office of the PL and LRO. And thereafter, my lord, I filed the report, my lord, details report, my lord.
Let a copy of the report may be served, lordship.
Land vested, my lord, as per section 4 and 5, my lord, Estate Acquisition Act 1953, my lord. Not West Bengal Land Reform Act 1955.
Take down.
Lordship, they have submitted a report, lordship. I have to take the exception to the report, lordship.
What report? I have not received any report of that. বসুন বসুন রিপোর্ট না দেখি সাবমিশন করছেন
Page 3 of my.
Give me a second, sir. Page number?
Page 3 of my report, my lord.
Yes.
Found that the plot number 962 by 1422 of Moja Jigiri such and such recorded in favor of the Calcutta government of West Bengal, my lord, on 27 June 1979, my lord, in Khatian number 1, my lord. Page 3, my lord.
Page 3.
Page 3, my lord. 962 by 1422, my lord, bus to 3 decimals. Thereafter, my lord, B, my lord, in my report, my lord, it is also found the said plot.
Page number? Page number?
My lord, that is the reported in my report, my lord. First page. It is also found the said plot is recorded in favor of Lakshmi Raj Jhikiria, Devota Sri Sri Ma Chondi Thakur Jiu, where Bagola Sundari Devi, such and such, and recorded as the Sebai. In the LR Khotian number 2123, this record was formed.
I'm sorry, which portion you are reading, I cannot find.
My lord,
first
page of my report, my lord, B, my lord, under B, my lord.
Oh, I see, B.
My lord, page 4, my lord, of my report, my lord. Starting, my lord, page 4 of my report. And
Just a minute.
Page, my lord.
As per, let us read from A. It is found that plot number such and such
That is
was
phase
read
three.
paper of the collector on 27/6 in Khotiar number 1, attachment number 1. Attachment number 1,
Phase three.
page 3. Very good. Then, sir, B.
B one.
It is also found that the said plot is recorded in favor of Lakhiraj, Chikira, Devotar of such and such. So, the record was formed. Later, the names of has been recorded as Sebayat. Attachment number 2.
That
Yes.
is phase 4, my lord. Relevant phase, my lord, phase 25. Case 25, my lord. That's it, got it, my lord.
Let me
Relevant
read,
phase
sir.
25.
Yes.
Plot number 962 by 1422, my lord. Vastu, Ghor, my lord. That is 3 decimal, my lord. Thereafter, my lord, the first page of my report, my lord. Page paragraph 2, my lord. As per correction list of the consistent plot number LL Khotian number 2123 recorded in the name of Lokira such and such, my lord. Page 28, my lord. Page 28, my lord.
How this name is transpiring, my lord?
My lord,
Sorry for interruption, lord.
from the top, my lord, third, my lord. That is the Daj Shuchi. And double writing, my lord, that is deleted, my lord. Thereafter, my lord, paragraph 3, my lord. In the first page, my lord. It is also found from the KB Khasra of Zikiria Moja, the said clause is recorded in the collector's Khotian being number 1 within 10,000 share and area 3 decimal with a noting of Purvotton, Modhyavati, Ganga, Madan Circle as per conjoined effect of notification by number such and such. My lord, relevant page 29, my lord. Next page. At the bottom, my lord. 962-1422, my lord. Thereafter, my lord, paragraph 4 in my report, my lord, first paragraph, first page, my lord. In computerized finally published LRROR, the said clause is recorded in the collector Khotian being number 1 with a share 10,000, my lord, with a 3 decimal, my lord. Page 30, my lord. Next page, my lord.
Anything more? Take down.
Lordship, the
My
report
lord,
may be
my
stated
first
to me, Lordship.
submission
I
is
have to take the exception to the report, Lordship. The
What
first
exception?
issue,
First
which
point
is
is that,
shows,
my lord.
Lordship, from my writ application is transferred from the
Give
record.
me a copy.
Yes.
That so far I have relied upon the documents, Lordship. It has been stated that Devotar CC March only.
The subject matter of
And they are saying
ওটা নিয়ে নি এভিডেভিট অফ সার্ভিসটা নিয়ে নেবে না প্রথমেই এভিডেভিট অফ সার্ভিসেস ফাইল
Actually, in this matter, I am appearing. The last occasions I have served affidavit of service.
Last occasion?
I have served affidavit of service.
There is no private respondent, I believe.
Yes.
There is no.
Consideration we are praying.
Yes, my lord, in these applications, I made an application before the authority concerned, my lord, according to their own sketch map. That portion was relinquished. That sketch map was published in the year of 1953. On that basis, demarcation will be made. That is still pending.
Which one, sir? Page number?
Page number 56. In this matter, my lord,
So it is your grievance that more land has been acquired.
no more land originally acquired. That thereafter, no publications of the sketch map was prepared, and 50% land was relinquished. That is 50 feet from the both side, and 50 feet that were acquired. And rest portion that is released, no compensation was admitted position. They have published a sketch map that is in the year of 1953. I am only praying, my lord, that according to their own sketch map, that land should be demarcated. Nothing more, nothing less. In the similar point, my lord also passed.
কি বলেছে ওটা দাও কি বলেছে Then Mr. Yusuf's names will be substituted with Mr. Banerjee.
Yes.
Make that correction. Otherwise, it will be same. Mr. Somir Ram. ওটা দেখে নিন Sure. Give the next.
Please, your lordship, I have got the petition. I'm led by Mr. Sabir Ahmed. My senior is appearing virtually.
Where is Mr. Ahmed?
I'm here, Lord. I'm virtually, Lord.
You are not in High Court?
No, Lord. In Delhi. Let's see. It's not appealable, but why I'm saying that your lordship would
Wait. Why is the affidavit of service? Who's for the state, Mr. Day? Where is the impugned order, Mr. Ahmed?
72 for a second, Lord. Can you take page 72?
Page?
This is page 72, Lord. The order passed by this honorable court by my Lord Justice Chaudhary, as his lordship then was, Lord, the issue pertains to Lord extension of lease period because Lord during the pandemic, the petitioner could not uh, excavate Lord the sand. There are 5 years lease granted to him. Now, Lord, pursuant to the representation made by the petitioner for extension of time and adjustment of the time, since Lord, due to pandemic, she could not uh, continue with the work. A liberty was granted to the petitioner to approach the authority, and the authority was directed to adjudicate the issue and pass a recent order. That is the order. They did not challenge that later on, but however, the finding of the competent authority is at page 76. Now, will kindly see what is the observation.
How to overcome the provision of Rule 51, sir?
Lord, I'll just show your lordship, Lord, this is violation of the agreement. Your lordship would kindly take Lord, page 22 for a second. I'll just come one by one.
Page number?
22. That's the lease agreement, registered lease agreement.
Page number 22.
Malak. That's the lease agreement. Your lordship would kindly see the bottom. I just want to show your lordship that this is for 5 years. Your lordship is similar.
Yes.
Now, Lord, your lordship would kindly take Lord page. There's a forced razor clause which your lordship will get at Lord page.
Oh, I understand, sir. But the order has been passed by the additional district judge. I'm sorry, additional district magistrate. That order is applicable under before the commissioner.
Lord, that Lord, subject lordship kind sanction, Lord, that is an exercise of the power in the administrative capacity pursuant to the direction passed by this honorable court. Now, Lord, the issue is very limited. This is not an order, Lord. Subject lordship would kindly see the order for a second. Kindly see.
Yes.
It starts from Lord page 76.
And the
very opening line of the authority is Lord. Before that, the lordship would kindly come to page 75. This is on 11/12/2023. Whereas the Honorable High Court at Calcutta by solemn order dated such and such, passed in petition number such and such, directed ADM and PLRO to dispose of the petitioner's representation dated 1st December 2022 in accordance with law after giving opportunity of hearing to the petitioner or his representative after taking into consideration if the petitioner was really prevented from excavating the sand during the period which urged in the writ petition. Now, I'm going to kindly turn to the next page. The order was passed pursuant to the leave or direction granted by the Honorable High Court.
So you will come to High Court.
No, this is not an order.
Pursuant to the direction of this High Court. And if there is how do you overcome the Rule 51? That is my simple question, sir. Already, when there is an efficacious alternative statutory remedies available, then why the court will exercise its prerogative power?
That is in respect of cancellation of the lease or not any order, any condition which has been stipulated in the agreement. If there is any violation and statutory authority passed an order in respect of that, my prayer was limited to the extent that since there was a pandemic situation occurred, which is beyond
Mr. Ahmed, law is very settled. The court can entertain a writ petition despite availability of the alternative statutory remedy only in 2 cases where the authority has no jurisdiction to pass the order. Second, where principle of natural justice has been violated. So for first point is concerned, I believe you cannot say that the authority was not authorized. He is within his jurisdiction to pass such order because of the High Court's order. Secondly, I found he has considered your representation. He has given the chance of hearing to you, and he has also considered your written notes argument. That is the settled principle of law I am referring the reported decision that is UP State Steel Spinning Company Limited versus RS Pandian another reported in 2005 8 Supreme Court cases 264. 2005 8 Supreme Court cases 264. Take down.
May I come back with some
No,
other
no,
judgments
sir,
where
nothing,
the
nothing.
violation of
You
national
no, no. You have
Your Lordship would kindly
the subject matter of the instant writ petition. The subject matter of the instant writ petition is the
then may
order
I come back with
dated
some judgments to satisfy your Lordship on the
not
point of
required, sir,
urgency.
not required. The subject matter of the instant writ petition is the order dated 29/1/2024 as case number M and M /17 of 2023 by the respondent.
ठीक है पाटिल चारी फोल्डमध्ये आपल्या त्यात काय काय नव्हतं Lord, may I say something, Lord? The observation, Lord, may not prejudice the Lord, the appellate authority. Lord, you would kindly record that, Lord.
Stop para. It in favor of him. Full stop para. As rightly pointed out by Mr. De and Mr. Saha, that Rule 51 of the said rules of 2016 clearly mandates that an appeal shall have to be preferred against the order of the respondent number 4 authority if the writ petitioner feels aggrieved at all with such order. Stop. In view of such availability of alternative efficacious statutory remedy, this court finds no reason. This court finds no reason to entertain the instant writ petition, especially when no case has been made out on behalf of the writ petitioner that the impugned order is passed by an authority who has no jurisdiction to pass it, and oblique or while passing the impugned order, the respondent number 4 authority had violated the principle of natural justice. Stop para. Such proposition of law has been elaborately discussed in the reported decision of UP State Spinning Company Limited versus R.S. Pandey and another, reported in 2005-8 SCC 264. Stop para. In view of the discussion made in the foregoing paragraph, this court finds no merit in the instant writ petition. Accordingly, WPA number 28994 of 2024 is hereby dismissed. Stop para. There shall be, however, no order as to cost. This stop para. It is, however, made clear that while disposing the instant writ petition, this court has not gone into the factual merits as involved in the instant writ petition. Stop para. Before parting with, it is, however, made clear that since the writ petitioner is pursuing his remedy before a wrong forum, this court, while disposing the instant writ petition, grants liberty to approach the appropriate authority in appeal if so advised on the self-same cause of action, and in the event such an appeal is filed within 30 working days from today, the appellate authority oblique the appropriate authority shall consider such appeal within the period of limitation.
Obliged, but I was only praying for that lead, Lord. Obliged.
Sir.
Only one senior Miller.
Sorry.
Question of my senior Miller, only one more indulgence, Miller. If your lordship considering that this issue is since 2022, Lord, date specified.
No addition, no alteration. Call the next.
30 days we'll file the appeal, Lord. Obliged, Lord.
Mr. Swami, not 30 days, 30 working days. Because Puja vacation interval.
Obliged, deeply obliged.
One thing, make it 45 working days. Puja grace.
Obliged, deeply obliged.
45 working days. 45 working days. এটা কি? মনে করিয়ে দিও বাবা। Has prayed for on behalf of the bid petitioner.
Your Lordship, in item number 9 and 10, both the matters I am led by Mr. On Banerjee Lordship. He, due to his personal difficulty, he has to left court today. I am praying if your Lordship.
Mr. Banerjee was right there.
He was there due to his personal difficulty. He just left court today. He is requested if your Lordship may kindly fix this, both the matters at 2 p.m. Lordship.
2 p.m.
2 p.m. Lordship.
Today?
Today 2 p.m. Lordship.
Oh, they have some difficulty. 2 p.m. What is the difficulty?
Great.
9:10, 2 p.m.
9:10 both matters.
Very good.
Great.
Respond number 4, I have filed an application for dismissal. It is outright abuse of process by them.
Last occasion, your Lordship directed us to serve. Well, I have served on my lord. The state and my waiver is the
Who is the state? Who is for the state? Who is for the state then?
Well, the state is required because my representation has to be considered as at the
Yeah,
end of the day.
unfortunate.
Well, I have
Despite service, state is not appearing.
will kindly see the Lordship's order has been commissioned. This is
Just a minute, sir. Just a minute, sir. Since none appears on behalf of the respondent state, there is a responsible advocate for the representative hereby requested to intimate the next date of hearing by issuing a notice in writing along with a server copy to the chamber of the legal remembrance, sir, to file receipted copy. But abandoned department was also directed to forward a copy of this order to the law. What is the report? Which for the state? Nobody is appearing. Sir, you are appearing. Then Mr. Bandyopadhyay, you please appear.
This same because the arbitrator couldn't get an order.
Mala.
Injunction suffered, now he's
No, well, it's a different thing, Mala. Mr. Mala, senior friend is on Mala. Mala, he has a remedy there. Mala, I am not objecting to that. Now, my prayer is very limited, very limited.
একটা লাইন লিখে দিন তো the affidavit of
একটা অনলাইন কপি দিয়ে দিলে হবে আপনাকে? অনলাইন কপি
অনলাইন করে বার করবো কি করে?
অনলাইন করলে নেই
ও 3 বার সার্ভিস করেছি,
রাইস
3 টাইমস। কি করবো? মানে আউট অফ ইয়ে হয়ে গেছে। এই
Yes.
Who is for the respondent number 9?
9.
Srinath Singh Roy.
That has been served. Again.
No, on the last occasion, he has appeared.
Oh, sir, yeah.
On behalf of the respondent number 9, pay accommodation has been separate for.
Mr. Sinara happy.
Who is the answering respondent, sir?
As well as state. Then my land has been utilized without any acquisition. Litigation is continuing. Single bench, honorable division bench, review, then contempt has been dropped, giving liberty to move afresh. That's why you are before mine. Not kindly to have an history, kindly come to page 97 of your lordship.
Yes, Mr. Basu.
Kindly come to page 97.
I'm there.
Second paragraph, third paragraph. The report submitted.
Yes.
Can I read that? Report submitted by the Learned Council appearing for behalf of the state respondents indicates that 10 feet wide road has been constructed under the Mahatma Gandhi National Rural Employment Guarantee Scheme over the plot in question, which is being utilized for public purpose, meaning thereby that the plot has been utilized. There is nothing on record to suggest that the plot was acquired or compensation paid for the same. Contents of the petitioner in the petition remains uncontroverted. Then the prima facie, then, in view of the above, the writ petitioner disposed of directing the 11th respondent to take necessary steps for assessment of compensation payable to the petitioners and payment of the same to them for the plot in question at the present market rate. At the present market rate. This was, my lord, sometime in February 2022. My lord, appeal has been preferred against the order. Can you come to 99?
Yes.
Appeal has been preferred. In the appeal, my lord, it is not in dispute that the land of the petitioner has been utilized for construction a concrete road. Since the petitioner did not receive any compensation, they approached the landed single judge. Then, my lord, kindly turn over the page. Kindly come to 100. Last paragraph. It is not in dispute that what was once a village road has been converted into a concrete road by utilizing the land of the writ petitioner. A citizen of his country cannot be deprived of his property except in accordance with law. Thereby, my lord, the trial court's order has been upheld. That your lordship will get at page 101. However, if the Panchayat says that it is constructed the concrete road under the direction of the state administration, nothing will prevent the Panchayat from approaching the state administration for assessing compensation and providing funds to pay compensation to the writ petitioner in terms of the order of the landed single judge. This was again, my lord, see my fate, against it has been reviewed.
Reviewed before the honorable division bench.
Before the honorable division bench.
Page number, sir?
Page 106. I will not reiterate. Shall straight away come to 108. What was also frustrated. Accordingly, we make it clear that whichever authority, be it Gram Panchayat or the Panchayat Samiti or any other Panchayat authority, constructed or caused to be constructed the concerned concrete road in question over the land of the writ petitioners, the direction contained in our order dated such and such will be taken into the direction against such authority.
So whichever authority has utilized, he has to pay.
They are playing. They're not me, he, that. Then next page. To avoid all further controversies, we direct the concerned block development officer, being the executive officer of the Dashpur 1 Gram Panchayat, to take up the issue of payment of compensation to the petitioner and
act in terms of the deduction content in the order of February 15, 2022, passed by the Honorable Single Judge. Exercise within 2 months from the date of communication of this order.
Then what happened?
Then, my lord, contempt. Contempt order হচ্ছে 10.
Page number?
Just a minute, my lord. I am 1010. এটা কেন?
Last order?
No, no, no. Kindly come to 191.
191. Last order. Last order. E70.
But in the contempt proceeding, my lord, we were clamoring for going to the question of compensation that has been granted. Am I clear to my lord? Contempt, we tried to convince the court that this meager amount has been given. You, the court, jurisdiction of contempt court, can exercise it and decide the compensation. We are asking something more, which is the ultimately, my lord, the division bench in the contempt proceeding held that you take steps in accordance with law. Kindly come to not the relevant every portion, my lord, will be kindly come to paragraph 13 at page 195. In such view of the facts, the court is of considered opinion that there has not been any disobedience by the alleged contemptor of the court's order in order to espouse the court's contempt jurisdiction as prayed for. Hence, the contempt application would not be maintainable. The question now relates to dissatisfaction of the petitioner as regards the amount of compensation so arrived at by the said block development officer and executive officer Daspur 1 Panchayat Samiti.
So they have assessed the compensation.
They assess a meager amount, not in compensation with the circle rate. Now the government is saying you go by the circle rate. My lord, is in the land judiciary every day, my lord is looking at that. Allegedly, the compensation amount has been determined not in accordance with the commensurate to the prevailing and appropriate market value. This is a finding. Hence, the amount of compensation as
No, allegedly.
Hence, the amount of compensation as determined is erroneous and not maintainable. However, since the compensation has not been determined in a duly established procedure and manner of determination of land acquisition compensation, the petitioner here would not be eligible to pursue the statutory remedies to challenge the quantum of compensation to so determined in accordance with the provisions under the relevant statute relating to land acquisition. My lord, will appreciate, my lord, I cannot go for section 18, old like section 18. In exercise the competent jurisdiction, the court is only to see such and such. Hence, in this order, though having hold that no contempt of the court's order has been committed by the block development officer and executive officer 1 Panchayat Samiti, the court is inclined to direct further that the petitioner shall be at liberty to approach the appropriate court of law to challenge the order of compensation as passed by the said development officer executive such and such, if at all as if it was an order passed by the competent authority in a duly initiated proceedings for land acquisition in accordance with law. This is in addition to and not in derogation of any other remedy that the petitioners may take recourse to in accordance with law. So now, in view of this order, I am approaching a Lordship's court, the single judge, to ventilate my grievance. Because under the Land Acquisition Act, I have no remedy because there is no award passed. Am I clear to my lord? So I cannot, reference court, I cannot go.
So what is the order of the PDO?
Yes.
That is the prayer.
অর্ডারটা ছিল
অর্ডারটা প্লিজ 116 ওইটাই তো তোমরা চেয়েছো দেখো না 178 পাতা
Yes.
তোমার প্রেয়ারে লেখা দিতে
See the
অর্ডার ডেটেড
Page number 178.
He starts
Mala,
from
it's a report. It's a filed in connection with the contempt application. They prayed before this honorable court for setting aside of this order. This is the prayer, Lord. But this is the report. Report in connection with CPN number such and such, MAT number such and such, in compliance of the such and such.
No, they are agreed with the quantum of assessment. What is that?
That order, my lord, just a minute.
My lord, may I submit?
No, wait.
খুঁজে নিয়ে এটা
কোয়ান্টামটা তুমি দেখো 183 পাতা দেখো
দেখেন কোয়ান্টামটা
183 পাতা
অর্ডারটা দেখেন এক সেকেন্ড জাস্ট মিনিট my lord.
ওটাতেই বলা আছে ওটাতেই বলা আছে
Yes. Kindly come to.
You have challenged the order dated 20th February 2025.
Kindly come to 182. Page 182. মাঝখানে একটা পাতাই নেই।
No, you challenge the order dated 20th February.
February?
Yes. Page number 25, sir. Your prayer.
No, 20th February order খুঁজে পাচ্ছি। But once kindly come to 18th February order 182. This is the valuation that I am challenging. Kindly come to 182.
Yes.
This is the order dated 18th February 2025. Can I read that? The case is taken up for giving compensation to the concerned petitioner. Among the 5 petitioners, only 2, namely C. Devoti Rama Sajjad has appeared. Panchasumiti and filed Hajira. Besides, at the same time, the concerned ADSR Daspur 1 remained present in response to the letter from his office memo number such and such. The points come out during conversation as per given below. First, opinion of the present petitioner as heard in brief. The synopsis of the fact is described in brief to them. The concerned ADSR briefly explained the pros and valuations to them on the plots in question, and thus the valuation of the said quantum of land is fixed as ₹10,87,000. They are offered to take the compensation, that is the amount of ₹10,87,000. After thinking a while for the same, they finally refused to take the said amount. They further said that they are unable to take the compensation without consultation with the main petitioner, that is Kartik Kapas. As the concerned ADSR Daspur 1 prepared the valuation of the said quantum of land with his best knowledge and belief, the undersigned is also agree with the said valuation of land and ready to give compensation amount of ₹10,87. No discussion. Why? Nothing to be discussed. See the circle rate. Quantum of land admitted up to High Court division bench and apply the circle rate. Apart from that, we have produced the local deeds. And my lord, we have the judgment with us. Your lordship's court judgment. If it is a compulsory, this is my lord, with acquisition without proceeding, then 10 times of the market value we have to pay.
Probably they have adopted the direct purchase policy.
You cannot.
Milord, may I submit? They moved the earlier writ petition before this honorable court. My learned friend, my lord. First, my lord, your lordship, shown the order, page 97. Page 97, my lord, the passed by the London single bench on 15th February 22. Third paragraph, my lord, he has written, I again written, my lord. The report submitted by the London Council appearing on behalf of the state respondent indicates that the 10 feet wide road has been constructed under the Mahatma Gandhi National Rural Employment Guarantee Scheme over the 14th question. My lord, that is the 100 days work. Mahatma Gandhi National Rural Employment Guarantee Scheme, GNR, called my lord Munrega. My lord, there is no scheme for my lord the land acquisition, only to provide the people, my lord, 100 days work. This road has been constructed. My lord, there is no dispute. The petitioner's land has been utilized. 10 feet, my lord, the road has been constructed. Previously, my lord, a report was submitted before this honorable court. One minute. Page 190. রিপোর্টটা কোথায় গেল?
20 অর্ডারটা করতে পাবো 18 হবে। This is a mistake. It should be 18 February.
Huh? Page 81 page. That was filed before this honorable court at the time of Milord hearing. And pursuant to this Milord, this order has been passed.
ঊর্ধ্বতন কর্তৃপক্ষের নির্দেশ অনুসারে আমিনবাবুকে সঙ্গে লইয়া দাসপুর 1 ব্লকের মেরিট মিলন দাসপুর মৌজায় সরজমিনে তদন্ত গিয়া দেখা যায় যে রবিদাসপুর নদী বাঁধ হইতে পিয়ারবেরিয়া হাই স্কুল পর্যন্ত এমজিএনআরইজি প্রকল্পে একটি 10 ফুট চওড়া ঢালাই রাস্তা নির্মাণ হয়েছে। উক্ত স্থানে বহুকাল পূর্ব হইতে 5 ফুট চওড়া মোড়াম রাস্তা ছিল। বহুকাল পূর্ব হইতে 5 ফুট চওড়া মোড়াম রাস্তা ছিল। ওই রাস্তা দিয়ে গ্রামের মানুষ চলাচল করিয়া থাকে। উক্ত রাস্তাটি মৌজায় নকশায় নেই। আবেদনকারী কার্তিক চন্দ্র প্রকাশ ও অন্যান্যদের অনুমতি ব্যতীত উক্ত ঢালাই রাস্তাটি নির্মিত হইয়াছে। Therefore, my lord, it is my lord the established the petitioner's land has been utilized. And well, pursuant to this, my lord, this honorable court has passed this order. Appeal preferred, well, appeal, my lord, confirm this order and review, but that is the, my lord. And pursuant to this, my lord, the honorable court directed to pay the compensation, and accordingly, my lord, the BDO, Daspur, my lord, requested the ADSR Daspur for assessment of the valuation at the present market rate. First market rate, my lord, assessed. And that first report, my lord, your lordship kindly turn to page 119. That is filed in, my lord, review application. 119. Yes. My lord. In the meantime, my third, fourth paragraph. In the meantime,
Page number 190 or 19?
119.
Oh, I'm sorry.
119.
Give me a second then.
In the meantime,
Give me a second. Let me read that. I'm not so fast like you, sir.
Sorry, I have not seen my lord that you have done.
Yes, sir.
In the meantime, my lord, ready 1, 2, 3.
Yes, I got the point. Yes.
In the meantime, ADSR Daspur 1 also requested to assess the present market value of the suit land and submit the report to the undersigned before the hearing date. On the hearing date on such and such, out of 5 petitioners, only petitioner, namely Kartik Chandra Kapas, such and such, was present. So, copy and close. That as per report of the ADSR Daspur regarding the present market value as per the R1, 5,15,500 only, which is informed by the petitioner, ask the petitioner to furnish the bank account such and such. Lord. Thereafter, and the petitioner submitted a representation before the hearing table regarding recalculate the present market value of the suit plant on behalf of the petitioner. Hence, the representation is forwarded to the ADSR Daspur looking into the matter and submit a report, a representation, video office number such and such. Accordingly, my lord, that has been sent to the ADSR to look into the, and he reassessed, my lord. Valuation has been enhanced from 5 lakh to 7 lakh.
Well, we'll get that.
My lord, that, and even my lord, I have not found, my lord. একটু তকলিফে না এটা নয় and that has been enhanced, but he is, my lord, again, my lord, called for, and he submitted the other documents of the 23 deeds, my lord, in respect of the contiguous lands of the plotting questions before the ADSR, and that has been again reassessed. Page 144 page, 144 page, yes, you are right.
145.
145, my lord, reassessed, and my lord, total market value reassessed 7 lakh.
Just a minute.
By the ADSR.
Place, sir.
145, your lordship got it?
Yes, place.
Then, my lord, again.
No, place for 144.
144, my lord, starts, my lord. forwarding the revaluation of the students as per records available ROR.
Yes.
Market value, it has been assessed by the ADSR, my lord. And last page, my lord, total area such and such, total market value assessed, the sale land 7,61,000 such and such. My lord, but the petitioners, my lord, raised before this question, my lord, before the honorable court, that his land, my lord, is more, not 30 decibel, my lord, it will be, my lord, 43. And my lord, the honorable court again directed them to reassess, my lord.
I have not completed, my
That I'm bolining.
I have not, the system is, petitioner will say first, then respondent will say.
We have said.
No, I have not stopped.
Then who made you stop? I have not stopped you.
I am finding some document, he started as usual.
Well, again, my lord, it has been reassessed.
No, if the total market value was assessed to the tune of 7 lakhs, 761, then why you are giving 10 lakhs and all?
Then, my lord, again, my lord, P16, page 178. That has been
page 70?
178. That is filed in connection with the, my lord. No, contempt application. That is under challenge, that is the prayer. My lord, may I read?
Page 178.
Page 360, page 178. May I read, my lord?
Yes.
Report in connection with CPN number such and such, in MAT number such and such, and pursuant to order dated such and such, in the matter of Kartik Chandra Kapasani. In compliance of the order dated 25th April 2024, passed by the Honorable Division Bench in the instant contempt application, the phrase valuation was sought for from the ADSR memo number such and such for 46 decibel of land, situated such and such, at present instead of 30 decimal of land. Previously it was 30 decimal, now it is 46 decimal. Accordingly, the ADSR Daspur 1 filed his memo number such and such, submitted valuation report to the BDO Daspur 1 after assessing the valuation present market rate. After receiving the aforesaid assessment report, e-assessment slip, a notice was issued upon the petitioner on 10th February 2025. Read a memo number such and such to receive compensation amount for 46.364 decimal of land as assessed by the ADSR Daspur on 18th February 2025 at 1 p.m. That on 17th February 2025, 6:35 received the email from the main petitioner Kartik Chandra Kapas, from where it appears the petitioner is unable to accept the compensation amount as the matter is pending for the petition bench. As the valuation of the land as per assessment slip, compensation has been assessed 10,87,732, and accordingly check bearing number such and such is ready for handover upon the petitioner. On 18th February, 2 petitioners among the 5 petitioners remain present, but they refuse to accept the said amount without consent of the petitioner, namely Kartik. All the aforementioned is such and such, all the documents enclosed such and such.
So, according to you, Mr. Bandyopadhyay, appropriate, the procedure has been followed for assessing the valuation. That is your case.
Very good. Then, my lord, your lordship, kindly, the order, my lord, the which has been shown, my lord, 18, my lord, the 5 out of 5, 3 were present before that, and the order sheet has been prepared. That is, my lord, page 81, and last order, my 18th, on which date they were asked to present to take the receipt the check. Well, your lordship, kindly turn to page 183. That is the valuation assessed by the ADSR pursuant to the BDS order.
Yes.
183.
Yes.
Subject matter, valuation of land as per ROR and records available in the database at GL number such and such, in WPA number such and such. In response to your letter memo number dated as it is notice that the valuation of 46.364 decimal of land instead of 30 decimal is required as per ROR and current data from the online record available since 2007. I found only the market value of 5 plots as per referred deed number such and such, and the remaining 23 plots as per our existing database through the query number such and such. As per the order issued by the Honorable Division Bench of the Honorable High Court at Calcutta on such and such, the valuation of 46.364 decimal of land, being assessed as per my best knowledge and belief. The total market value of 46.364 decimal is 10,87,732. This is for your information and assessment. My lord, this is the valuation last assessed. And my lord, pursuant to this report, my lord, the honorable court, my lord, contempt proceedings dropped. My lord, he is agreed with the valuation assessed by the ADSR. If he is assessed, my lord, the valuation is not correct, there is a provision of appeal before the IG or DI. My lord, I come with the, my lord, the circular latest and valuation of registration in pursuit. দেখি না তো নিশ্চয় দাদা In pursuance of the decision taken by the competent authority, it is directed that all valuations required for non-registration purpose must be routed through the appropriate documents of the state government. However, it is to be noted that the valuation asked in relation to any court cases and adjudication process shall be forwarded directly to the directorate allowing necessary valuation group. Therefore, my lord, let them approach before the authority if they are dissatisfied with the valuation assessed by the ADSR.
Which authority?
By the directorate. This issued, my lord, by
Directorate of Registration and Stamp Revenue.
Commissioner of Stamp Revenue. This is issued by the Inspector General of Registration and Commission.
What should I say? This is the respect of registration. If I present it for registration, valuation is wrong, you can go there.
Is there valuation with regard to the non-registered? Anyway, what is your submission?
No, my lord.
What do you want to submit more, sir?
I'm sorry, my lord, that I'm finding some document that is started.
Very good.
Here is the case admitted, my lord, my land has been utilized without an acquisition. This is admitted fact. Initially, they tried to deprive me saying that you have 30,000 for the...
No, anyway, now you are agreed with the quantum.
No.
And there, according to you, there is a opaqueness in the quantum.
There are 3 reports filed before this court, 3 valuations.
5 lakh, 7 lakh, 10 lakh.
5, then 7, then 10.
According to their representation,
please, I'm yes. First, when the Lordship Court directed to put the valuation, they say it is 5 lakhs. Then we are dissatisfied. We say this cannot be done.
So what happened? That hasn't happened.
Happened. Now
tell me why you are dissatisfied with the quantum.
Quantum is that, kindly see, there is no finding at all. Nowadays, after the circle rate was introduced, there is no question of any assessment comes in. Circle rate, government is declaring. Apply the circle rate vis-a-vis my land, quantum of land. Result will come out. We have assessed, my lord. It will come 17,56,908 in view of the present circle rate of that area.
Assessment slip.
assessment slip.
Assessment
that
slip.
is, my lord, the circle rate.
But he has also.
Kindly see page 182. Kindly once come to 82.
No, on the day of he has also relied upon the assessment slip.
Where is that assessment slip? Is there a deflection there?
184 starts from 184.
This is the assessment slip.
No, page number 184.
Yes. Can you see that? What is that slip? I want to know that.
We know 184 is there.
This one. Well, kindly see the finding. Ultimate finding is at 182. That is the order. 18th February 2025. Is there any reflection here? What he had relied? This is the order we are the challenge.
182 based on 183. And 183 is based on 184 to 190.
May I? This 182 has no reflection of 183. May I read? If I am wrong,
I've seen.
Yeah,
I've seen.
Any reflection? ADSR says 10,87,000. What is the circle rate? What is the quantum multiplied by
Those
this?
are available at 184 onwards.
184 onwards says no reflection here. That I want to show. Evidence may be there, but the order must reflect the evidence. I did not say true before my lord. If an order is passed based on evidence, in the order itself, evidence has to be there. That these are the evidences by which I come to this conclusion. Now, this is the Circle rate, we have, this is Joseph K. But kindly see the circle rate.
184 এর সঙ্গে মেলান দেখুন একই এটা তো আলাদা বেরোচ্ছে একই প্লট আলাদা
Same plot. Can you see that?
184 পেজ 84 এর সঙ্গে মেলালে সেই ভ্যালুয়েশনটা যোগ করে 17 লাখ অ্যামাউন্ট
This is a mathematical calculation, nothing else.
একই অথরিটি কি করে আলাদা দিচ্ছে তাহলে
Which one is to be believed?
থেকে নিচ্ছে না
Ashul, বুঝেছি। May I submit one thing? They have not made ADSR, my lord, as a party respondent. Because they are the valuation assessed by the he, it cannot be, my lord, contradict.
Unreported টা দে কি হলো ওই তো
দাও কি বলছেন
Sir, kindly see, this is an order passed by the Honorable Single Judge.
Let them serve a copy, my lord.
My lord, copy down now. My lord, kindly come. This is a case of utilizing the land without, my lord, acquisition proceeding. Kindly come to page 3 of the judgment. This is a very unfortunate case where I find that an organ of the welfare state is occupying the citizen's property as a trespasser. Same here. As such, I feel that for such unauthorized occupation of the petitioner's land, the state respondent is liable to pay damages, which will be not less than the 10 times of the letting value of the said land of the petitioner. It is for letting only. Now you are going to take my right. You are taking my land. Whether the similar ratio will not be applicable. Another judgment, my lord, I want to show to your lordship. Obviously different case. Very different. 2011 Supreme Court cases. Kindly come to
subsequently less, but it is not the case of that.
Kindly come to paragraph 13. Though the respondents are not entitled to interest under section 28 of the Act from a date prior to the date of preliminary notification, they are entitled to damages for wrongful use and damages of the land from the date of possession till the date of notification. What is that quantification here? Here is a case where, my lord, land of the petitioner has been utilized without any notification. Had it been a case of, my lord, land acquisition proceedings, I could have challenged in a proper procedure.
This has already been decided by the, my lord, and single bench and the division bench, my lord. This cannot be, my lord, agitated. And here and now.
In this case, my lord, taking into consideration the division bench judgment, I have a right to get a fair compensation, not in accordance with the land acquisition proceeding.
The
jurisdictional ADA, sir. The copy we just handed over to my lord today.
This cannot be taken up by this.
So that is the difference. That is the we obtained from the directorate that assessment slip valuation are different.
Numbers.
My lord.
He was not there. Everything was coming, taking adjournment.
কি হয়েছে এখন কি হবে?
Milord, item
Item
number
number-
1, Milord.
কি ছিল?
It was taken adjournment on the previous occasion by my learned friend.
He was here on the previous occasion.
Let me come back at PM there.
My lord.
Who is for the petitioner?
But I'm appearing on them.
But why are you not doing the case?
So Krishna Chaudhary was there appearing with her. So that is the reason why.
Sir, don't take any names, sir.
No, no.
I'm not a. Ma'am, I express my mind. I express my mind. Only today it will retain its position same. In the event a passover is taken, on tomorrow, appropriate order will be passed.
I am appearing for the petitioner, Lordship.
Mr. Banerjee, where is he?
He is on his way, Lordship. May I just place in the facts in brief to your Lordship?
No, if you will do, I'm not discouraging you, Mr. Junior Banerjee. But if you are agreeable, but you have to complete, sir.
Lordship, I shall.
So then at that material time you could have done. Who is the other side? Who is for the state?
Item number 9, Mr. In 10, Mr. Botobal is appearing. In item number 9, Mr. KJ Yusuf and Mr. Purikit Goswami.
Is it covered by my any judgment?
It is covered by the judgment of Shobhita Mondol's case, Lordship, a full bench judgment passed by this honorable court. And
very good. Place your case.
Lordship. This is the predecessor of the petitioners. They were originally the owners of the land which was acquired by the state for Mahananda embankment in the year 1980. See, if your Lordship may kindly take the list of dates in the application, in 1975-5-1979, the state has taken possession of the land in question. Subsequently, in the year 1986, on 12th of May 1986, the
list of dates
of my application, Lordship.
Just a minute. Yes. State took possession of the land in question of the writ petitioners. In which date?
On 25-5-1979, Lordship.
হবে না এই দেখো মিস্টার ব্যানার্জিকে দেখো
I'm sorry, Lordship. If your Lordship may kindly take item number 10 first, Lordship.
Yeah. No, I take 10. Very good. Give 10. Item number 10 দেখতে বলছে
এটা দাও তো
Same prayer?
Same prayer. Similar prayer, Lordship. 2 acquisition proceedings are there. So therefore, 2 read applications.
Very good. List of dates.
List of dates, Lordship. On 25th of May 1979, the state has taken possession of the land in question. On 12th of May 1986, the notice under section 41A of the 1948 Act was published. Subsequently, Lordship, there was no award was passed. And then on 2003, on 26th of June 2003, the notice under section 93B has been published. And in my submission, Lordship, even before publication of the notice under section 93B, the proceeding has stood lapsed. So therefore, if a proceeding stands lapsed before there is no process, there is no provision for revival of any lapsed proceeding, as amended in the law.
It is the case of Act 2 of 1948.
Lordship.
Colonel, I'm got to start. Baba. Mr. Banerjee, give me a second. So, Mr. Banerjee, if we go by 12/5/1986, it stood lapsed as per section 7A.
As per section 7A, Lordship.
7A of the Act 2 of 1948.
Lordship.
Because
It should be from
make an award under section within a period, 3 years have elapsed.
3 years have elapsed.
And if we go by 9(3)(b, even then
It was declared.
it has to be declared within 2 years.
Within 2 years, Lordship. Even the post
As per the West Bengal amendment,
notification, there was no award.
So,
Within
what
2
is your
years.
prayer then? They have to start a proceeding
My
for
prayer is
the
to
under
return
the
of
Act 30 of 2013,
Act of
and you have to
2013,
entitled to get the.
We have. I mean, my main prayer is return of the land lordship. In the alternative,
The prayer is not for payment of compensation. They have only prayed for return of land.
The court can mold the prayer.
My prayer is.
Court can mold the relief, sir.
Where
Land has been utilized. What is your report?
Report, I have got report from the requiring body. From the report of the requiring, it is not appearing whether the report is not appearing from the land acquisition. We have to take instruction from the land acquisition authority. We have not yet received. And so far as the LA case is concerned, LA case is of 1978-79. After 44 years, they are coming to this court.
Be that as it may. You have utilized your land and you will not. You want to come back with report?
The report is required in this one.
Then your lordship, I am just only beseeching if your lordship may kindly fix the matter before in this side of the vacation, lordship.
For this side of vacation, how it is possible? If you are agreeable, I can direct them to initiate a proceeding under 2013 Act.
Lordship, perhaps that will. If your lordship may kindly take note of, may I just place this judgment, lordship?
Take it down.
item number 9, I am referring Lordship. Lordship may direct this specifically to the land acquisition officer to dispose of the application which is pending before.
No, no, why should I? কি আছে দেখি তো? Yes. Which paragraph?
Your Lordship, the judgment is based on similar facts, Lordship. Your Lordship may kindly take paragraph number 18 onwards.
Very good. Let them submit a report. এই 9-10টা একসাথে করাবো। Since I
If they,
why should I, Mr. Banerjee, let them submit a report?
not as you know.
আচ্ছা একটা লাইন লেখো
Item number 39 for the petitioner, my lord, I'm paying for note today, my lord.
after vacation.
No, my lord, kindly make.
Let the matter
My lord, kindly not
on
today,
behalf
my
of the
lord.
writ petitioner and account.
I am for the petitioner lordship led by Mr. Jiaul Haq. My lord, the matter relating to unauthorized construction, my lord, considered disposal matter.
File be placed first. File be placed.
14 lordship, I am for the. Sorry.
No, I am not so fast. Where is the affidavit of service, madam?
Lordship.
It was initially hard.
Yes.
my lord. By me.
Yes.
Then
Lordship,
why it was not? Yes.
Lordship, I'm for the petitioner lordship. Lordship, the matter relating to unauthorized construction lordship, considered disposal matter lordship, but we erroneously made a party the assistant engineer of Diamond Harbour lordship, but it should be assistant engineer of Falta lordship. We collect the correct address of the executive engineer of Diamond Harbour lordship. I am praying for leave to serve the copy correct writ petition with fresh representation to the appropriate authorities lordship, and I am praying for lordship kindly dispose of this writ petition lordship for the further representation lordship.
Who is the appropriate authority?
Lordship, assistant engineer of Falta lordship.
Not Joynagar.
Not lordship, not it's item number 14 lordship.
Ganesh Parui.
Yes, lordship.
On the last occasion, my lord directed them to inquire about the parties. PLRO is not a party.
Who is for the state?
Mr. Bosu Mallik appeared last time.
Lordship, in this matter, Mr. Bishopnath Bosu Mallik appeared before the state lordship.
No, I find the assistant engineer Joynagar subdivision has already loaded data to the BLLRO.
My lord, this is item number 15 lordship. Same lordship, similar cause.
Incorporate appropriate respondent authorities.
Yes.
They have made party, my lord, executive engineer, PWD road. But
এটা কোথাকার রিপোর্ট কোথায় যাচ্ছে বলেন বাবু আমার তো 18350 রিপোর্টটা চাই এটা তো অন্য মামলা এসে গেল
1906 of 2025.
Item number 15.
Wait. In item number 14, who is for the state?
Lordship, in this matter, Mr.
Bosu Mallik appeared before of the state, my lord. He is engaged on courtroom number, my lord, 8.
Where is the report?
Yes, my lord. Hey, ওটাকে দাও।
সে বললো না ওখানে সেই 44 ছিল সেটা
কিছু করাই ছিল না।
এইখানে তো রিপোর্টের কোনো গল্প নেই ওরা তো পার্টিটা ঠিক হবে কিনা সেটা
রিলিজ করেছিল এর আগে ডেটে।
ওটাই লেখা আছে রিপোর্টে ওটা
সেটাই তো রিলিজ করেছিল। কিছু কিছু করেছিল তাই তো।
আমাদের কপি দিয়েছে
তাহলে ওইটা জিনিস হয়েছে
আমি তো হাতে ধরে আছি কেন
We assistant engineer of which place is the appropriate authority?
Lordship, the assistant engineer of Falta lordship. We erroneously made assistant engineer of Diamond Harbour.
সিওর তো
Yes, lordship.
হ্যাঁ সেটাই বলে দাও এগুলো তো নেসেসারি অর্ডার পাস করে দিন না
Do you know his address?
Yes, lordship. We collect the correct address of the executive engineer of Diamond Harbour lordship. This is a photographs lordship.
Keep it with you.
Oh, this is totally রেসপন্ডেন্ট নাম্বার 4টা অ্যাসিস্ট্যান্ট এমন হবে না ওটা ফলতে হবে তাই তো ওটা পাশে একটা ক্রস মারো তো রিপোর্টে কি দিয়েছে দেখ সে তো 44 করেছিল সেই সব মামলা
তো ডায়মন্ড হারবার ডিস্ট্রিক্ট
ও ওটা হবে না ওটা
Take down. Leave is granted. But otherwise, how do they?
15. Lordship,
Get him.
Lordship, item,
Identical.
no, Lordship, item number 15 also same cause of action, Lordship, similar cause of action, Lordship, different property, Lordship.
Take it down. Here parties are all right.
Lordship, same.
Same.
Same, Lordship. Joinago subdivision, Lordship, different. Mathurapur, Lordship, I have
None of them may have made party.
no, Lordship.
Very good. এটা কাজ করো report to you have filed today the report.
Customers adjourn this matter, but I have handed up this document because these are the documents which has not been before they have not produced these documents.
তাহলে লিখে রাখো Make the necessary corrections
Yes.
right now.
Well, that's right. Otherwise, not.
16, my lord, I am appealing for the petition. Lord, the writ petition is herein prays, my lord, for a direction whereby, my lord, the petitioner wants to construct a guard wall.
Give me a second, sir. Service has been affected.
My lord, that's what I'm being told.
Who are 8 and 9?
But they are, my lord, the obstructors if my lord takes up the cost title. 8 and 9 is the Jila Parishad Shavadipati.
But again, about 14 to 17.
Yes, Mr. Chatterjee.
My lord, what happened, my lord, the plot number 1208, which belongs to the petitioner, and there is no dispute to that. Now, my lord, adjacent to that plot lies, my lord, Damodar River.
Damodar River.
Damodar. Now, my lord, due to, my lord, soil erosion, my lord, the plot is, my lord, eroding away. Now, my lord, what happens, my lord, in the meantime, my lord, the state authorities, my lord, without acquiring my land, is trying to create a bridge, build a bridge, my lord, taking few portion of my land without acquiring. My lord, to that I have challenged. My lord, that writ petition is pending. There is an affidavit has been exchanged, a report and exception has been filed. Now, that has been mentioned before, my lord, it may come up after the vacation. Now, my lord, in the meantime, what is happening, my lord? The erosion due to this illegal excavation of my land without acquiring, my lord, my now
illegal
encroachment by the state upon my land without acquiring it. My lord, most of the portions of Damodar River is entering into my land and it's eroding away. Or major portion is now being eroding away. Now, my lord, for that purpose, my lord, as in his usual manner, river changing its course, my lord, it's eroding. My lord, I previously approached before the district magistrate. Kindly permit me to make guard wall at my own cost.
On the bank of the river?
On my land at the bank of the river. Absolutely. Now, my lord, the authority, my lord, initially was not considering. I came up before this Honorable High Court. This Honorable High Court relegated me, directing the authorities to consider my representation and case. My lord, the authorities took up my case. And, my lord, if my lord takes up the order, they passed an order, my lord, at page 57, if my lord takes up, of the writ petition. My lord's got page 57. It starts from page 56, my lord, the relevant portion would be from page 57. Maharaj got that? But whereas in compliance of the order of the Honorable Court, all concerned Executive Engineer Howrah, such and such, and the petitioner with his authorized representative has been requested to attend a hearing on such and such at 12 noon in the chamber of District Magistrate Howrah. Accordingly, they attended. Heard all of them, where Sri Joyantopal, the petitioner, expressed his desire that he will construct guard wall in his own land at his own cost for protection of his dwelling house from erosion of soil, and he assured that the flow of river will not be affected by the said construction under any circumstances. All attended officials had not raised any objection in this regard from their respective end. The petition is duly considered, and the petitioner Sri Joyantopal is allowed to construct the guard wall in his own land, that is aforesaid plot, at his own cost for protection of his dwelling house from the erosion of soil without obstructing of the flow of river under any circumstances. All they are hereby directed for necessary surveillance of the same till the end of total construction. Now, my lord, this order has been passed.
The private respondents are obstructing you.
now, my lord, they have come up and obstructing, my lord. 2019, COVID intervened, I cannot complete or touch it. Now, my lord, after COVID, my lord, when soil erosion started more, my lord, I went to construct that guard wall. My lord, now the private respondents are, my lord, intervening and, my lord, obstructing me from making that guard wall.
So where is the inaction and non-action on the part of the respondent state?
Now, my lord, I made a representation before the authorities to come and protect me and kindly takes up my representation, my lord. Which
Page
is
number,
at
sir?
page, yes, 58. No, representation.
58.
Not I'm led by Mr. Chatterjee, my lord. I'll let him.
You belong to your same family, so it is up to you who will.
If your lordship sees, my lord, my problem.
Complaining is illegal creating of obstruction.
Yes. Now it is for the state, my lord, to see that its order, my lord, is complied with.
So, Mr. Mukherjee, when you permit, you take appropriate steps so that he can construct.
And sees what's happening now. Kindly have a look. Have a look at this, what is happening now.
What is the latest position of this?
This is the latest position. It's all.
I do not know, my lord.
Let him take instruction. I don't have a problem, but this is the latest position.
My lord,
My lord, kindly sees the house that is there, my lord, that's my dwelling house. And the bridge, my lord, is in front of my dwelling house. That's on my land. I have permitted them to do whatever is required to be done.
Why have not annexed a copy of this?
This was at that point of time. I'll give a copy to my learned senior friend. Now, why do they want to delay it? I don't know any further. It is their order. I'm not challenging their order. I'm only asking for their assistance.
19 and 2025.
What, it has not become a time bird case, sir. It is a,
I'm not saying, but at this stage, my lord.
And I have allowed them to use my land to make that bridge, my lord, over Damodar.
Yes, sir. That's why I appeared before.
And one part, my lord, because of the river, my lord, changing its course, kindly see one part of my dwelling house has, my lord, collapsed. Kindly see, my lord, the portion which has collapsed, that's a part of my dwelling house.
Did not make any complaint against the private respondent before the, my lord, police authority also.
হ্যাঁ তোমার কাছে করেছি আবার পুলিশের
District magistrate.
Have a look at page 15. No, this definitely district magistrate.
No, order passed by the district magistrate.
Yes. আর কি করব?
Make any complaint, executive engineer or by the PLR or
61 দেখো.
copy to all. Copy sent to all.
Everybody.
no, take down.
Classical case of a commercial lawyer.
And he is not commercial at all. Not at all. Not at all. I think on your behalf.
Benevolent from the inception.
I know that. And last 3 generations are benevolent. Not only he.
No, that I cannot say anything. I must not comment anything.
Hey, every service de baba. Okay, na? This is renewal of Granite query license.
Who's for the state? Really?
Team number 18 is the same matter. I am for the
তুই এটা তো বি করছিস তো এটা তো করে যা he can appear also
same matter.
not identical matter similar
মুশকিল হয়েছে স্টেটের লয়ারদের নিয়ে Mineral Development Corporation is a party?
No.
Only state?
our grievance is only against it.
The affidavit of service has filed it on behalf
that is serving and he is appearing.
I'm really disgusted.
17 নম্বর ছিল
So, point are same.
I believe, Mr. Basu, this thing never happened in a high court. Now it is happening.
We have many things to see. Time passed, and we will see the hilt of the deterioration.
A very unfortunate state of the high court.
No comment. Sitting in here where the live streaming is going on nowadays. No comment.
Fail to understand.
But this matter,
The state government is so incapacitated that it has failed to appoint an advocate on this.
Appointment probably made, but he is somewhere else. Kali, don't open the brief. Kali, hear me for 5 minutes, then.
Give me a second.
Boss. I made boss.
Yes, sir.
Here is a case of renewal of a granite mining lease. On the basis of that lease, we have installed a factory there because granite has to be polished and then to be sold. And there are 400 employees are employed there. But it was moved before the Lordship's Court. Just to recapitulate, my lords, in the grant, there is a renewal clause. The renewal clause, if you logically recall, in tune with the Estate Acquisition Act renewal clause at the option of the lessee. I am reading for my lord the clause of renewal. কাজ করাতে চাইছি 102 Kali, come on. Clause 3. Clause. The mining lease shall be renewable for one period not exceeding the period specified in sub-rule 2 of Rule 12 at the option of the lessee. Provided, however, that the state government may refuse to renew a mining lease over the whole or part of the area covered by the original lessee for which renewal is paid for. This refusal right is not, my lord, cannot be exercised without any ground. My submission is this. What is the forfeiture clause in that? Kindly come to the forfeiture clause. Kindly come to page 77. Oh, sir, clause number 3. Roman part 9, clause 3.
Page number
106. In case, as well as got it. In case the lessee or his transferee, assignee, commit breach of any of the conditions specified and clause 2, 3, 6, 10, 26 and part 7, then and in such case, the state government shall give notice in writing to the lessee or transferor or assignee, as the case may be, asking him to remedy the breach within 30 days from the date of the notice, and if the breach is not remedied within such period, the state government may determine the lease.
Yes.
This is the determination clause. If you lordship read along with the renewal clause, the natural conclusion would be that if any breach is there, you have to give a notice for remedial breach under the Transfer Property Act. If in spite of the notice nothing has been done, you can do that. Now, so for the renewal, in this case, the client has applied for renewal.
It was for 5 years.
Yes.
Original lease for 5 years.
Original grant was 5 years. Thereafter, extended. Now it is 20 years. Then, within this clause. After this clause is there.
No, 28 July 2005.
So kindly come to the first page of that.
Page number 51.
28 July 2005.
It was initially for how many years?
If you lordship kindly come to page 48 of your lordship, please. 5 years will be granted to you on your complying with the formality. That is on 15th December 2004. Then, my lord, page 18 of your lordship, extension for 20 years. Page 50. Page 50.
Page?
Page 50. It's an extension for 5 years. On the same terms and conditions.
This grant order must be issued prior to the execution of the deed of lease?
This lease was violated shown to the previous
2005.
Yes.
It was in 2004. তার মানে তো আগেই হয়েছে।
2004.
So all are prior to that.
Yes.
So the registered deed was leased for how many years?
20 years. Here, my lord, next kindly come to 28th July 2005.
Page 53. Page 53, sir.
My lord is faster than
For the term of 20 years.
20 years. With the renewal clause.
That is there.
That is there. So I am just canvassing before my lord that the deed is executed continuing with the renewal clause. The petitioner applied for renewal.
What is the application?
Application. That probably if I placed your lordship's earlier order, everything is there. That application was rejected. It was moved before your lordship. Your lordship court passed an order, keeping everything open to consider the case. Last 175. 174.
My order?
Yes. That's why immediately to come to lordship's mind. Everything my lord has considered.
So page number 25 is the
paragraph 25.
Paragraph 25. I'm sorry. Is the main part.
Main part, but why are you showing to lordship? All other legal aspects has been considered by my lord. Then, in view of such, this court, while disposing of the instant deed petition, set aside the memo number such and such that the rejection. This court thus directs the respondent number 3 authority to consider the representation such and such for renewal of 2 mining leases afresh in the light of the observation made in the instant judgment, and shall, after giving an opportunity of hearing to the authorized persons of the writ petitioner company, shall pass a reasoned order and shall communicate the said reasoned order to the writ petitioner company, preferably by email in the such and such. The interaction has to be done. Now the order has come into effect. In the interaction, what happened, my lord? Well, one thing can you take a note from 2020-24, the commercial operation of this mining lease commenced. Admitted fact. Kindly come. Oh. Kindly come.
Okay, give me a second.
নটা কি করছো? কত নম্বর? One is reading your lordship's own order. তো বন্ধু ড্রাইভার
Yes, sir.
My lord has read out your lordship's order. Now, my lord, kindly come to the order impugned. That your lordship will get at page 208. First, not necessary.
Practically, I have indicated in by how the order is to be passed.
Right. That I want to show to you. Now, my lord, kindly come to 208. Kindly come to 2A. First part is a recital of your lordship's order. 2A. Two mining leases, deeds for mining of granite block situated at plot number 3310. Kindly pause here for a moment. 3310 is item number 18. My lord is deciding. It has nothing to do with 2974. That is another matter. Item 17. Then kindly read out. These are all, my lord, narration of facts.
Yes.
Kindly come to 211. Prior to that, all are narration of facts. Paragraph 6. It appeared from the records of the ICN department that the Todi Materials Private Limited renewal of two mining leases application suggested, but the applicant had not furnished the up-to-date clearance certificate of mining dues in original duly signed by the bearer. At the time of hearing, it was pointed out by the representative of the ADF dealer of Purulia that there was incidents of unauthorized mining and non-payment of penalty by the Messrs. Todi Minerals, such and such, and was conducted by the mining officer in charge, Purulia Zone, with representative of Messrs. Todi Minerals Private Limited on 30th January 2024. It was reported from the above joint survey that the petitioner had extracted 745.12 cubic meter granite from the outside of this approved leasehold area. During the hearing on August 5/86/25, the petitioner admitted the facts of unauthorized mining and non-payment of penalty from their end. But this admission is incorrect. I will show to you. This established deliberate non-compliance until faced with the adverse consequences. On 11th August 2025, the chief mining officer, West Bengal, informed that the petitioner deposited the dues. Deposited the dues through a demand draft dated 8th August 2025, an amount of rupees 17,31,367. The submission of the petitioner stated above has been examined in the light of Rule 16, read with Granite Conservation Development Rules 1999, and all the points mentioned in the written statement of the petitioner. The statement made by the petitioner and others present at the time of hearing was also taken into account. Rule 6.2 and 6.3 of the Granite Conservation Development Rules. A lease may be renewed for a period not exceeding 20 years. 6C. Notwithstanding anything contained in Sub-Rule 2, if the state government is of the opinion that in the interest of the development of granite, it is necessary to do so, it may, for reasons to be recorded, authorize the renewal of a lease for a further period of not exceeding 20 years in each case. Thus, it transpires that the state government may, in the interest of development of granite, renew a lease, but only for recorded reason and upon satisfaction that renewal serves the larger purpose of conservation and development. Renewal is thus not a vested right. The undersigned also consulted Rule 19.2 of the Granite Conservation Rule 1999. If the mining operations are not carried out in accordance with the mining plan as referred to under Sub-Rule 1, the state government or any person authorized in this behalf or the government may order suspension of all or any of the mining operations and permit continuation of only such operation as may be necessary to restore the conditions in query as envisaged under the said mining plan. In the instant case, the petitioner's conduct of unauthorized extraction beyond the leasehold area constitute a serious violation of statutory rules and lease covenants. Renewal of mining lease is not automatic. In view of established violation, the discretion vested in government under Rule 6.3 of the Granite Conservation of Development Rules 1999 cannot be exercised in favor of the petitioner. Allowing renewal despite violation would set an adverse precedent, undermining both the regulatory regime and public interest in mineral conservation. In view of the above, I am of the opinion that the prayer of the petitioner for renewal of the two granite mining leases granted in favor of the petitioner has no merits. Both cancelled 3310 and 2970.
So by a common order, both the matters have been disposed of.
One that I will.
Then I am to hear it at a time. I cannot pass two separate orders.
So why I am submitting, my lord, can subject to my lord pleasure. One is that I have done something wrong in respect of a agreement, a deed, and in another where I have did nothing can be equated. There is no allegation even.
In respect of another lease, another
no allegation, another plot, another agreement. And if you also see the assessment order is also in respect of 29 not in 3310. There also I have some
in this matter, subject plot is 2974.
No, 3310. 3110.
3310.
3310.
And
there is no allegation even.
Allegedly, you have made illegal excavation in which plot?
2974. That I also have case. I will submit when that matter will be taken. But here,
in respect of those two separate plots, separate lease deeds have been executed.
Yes. Otherwise, my lord, I could not canvass this point also before my lord. Separate mine, different entity, different tag number, everything separate. And the so-called penalty deposited without prejudice in that plot. I can show to you also the assessment order also in respect of that.
No, that's all right.
If this is saved, my lord, and this 400 people, my lord, before puja, they will survive.
Actually, The additional secretary has considered your past record, maybe in respect of a different.
Can it be done? I will argue in the 17. But here, in respect of the plot which is subject matter of independent lease, no violation. And I have shown to your lordship, my lord, the clause by which he can resume or cancel.
Yes. What is your submission? You paid for renewal for how many years, sir?
20 years. It's a running factory, my lord.
What is your submission?
As today, Lordship, I have received the brief, no instruction. I've taken up, Lordship, and can be considered.
Oh, I have not indicated that in the morning, at the first instance.
My learned friends, Lordship, saying that.
Don't waste the court's time, sir. Good afternoon.
Any day, Lordship.
400 or odd workers are there in the factory.
Whatever may be, Lordship,
Cancel, my lord.
Lordship unauthorizedly excavate the mines. That's why his renewal was rejected, Lordship.
Then you were ready?
Yes.
No, I am not
Then
ready.
why you
But I shall take the instruction, thereafter I argue.
কবে রেখেছি আগেরটা?
Thursday.
This court has Sir, if you are not ready, please indicate at the first instance. Wastage of time. Huh? এটা কোথা থেকে এলো? Call.
Right, appearing for the state, my lord.
No, appears on behalf of the written.
Yes.
কে আছে? The parties are not represented. Who is for the state?
Manager is for the state, my lord. He's coming. He's on his way, my lord.
May I take up?
Yeah, my lord. 5 minutes pass away. Kindly be granted, my lord. I can inform him once again.
Pass away for some.
Yes.
Who is appearing? With same order as 22. Same order, same date. For dismissal, yeah? For dismissal.
I'm for the petition.
No, I'm for the private respondent.
In this matter, I am for the state respondents, my lord.
The allegation of my lord, this land of the petition about the school that it were the occupied by the private respondent for construction of my lord the shop room. The school my lord is the owned by as sponsored government sponsored school. My lord, the allotment has been given by the government 2 acre and some or my position certificate is at page 19.
Page number?
Yeah. Page 19 is the position certificate in favor of the school.
My lord, one portion of land of the school is, my lord, encroached by the private respondent, my lord. This is the allegation, my lord. Now, my lord, school authorities are not, my lord, it is the, my lord, kindly issue a notice to the school authorities to appear before your lordship. So that the school authorities, the school was, my lord, the school is Lal Bahadur.
Local persons, these things, schools land has been occupied by the private individual. That's why I am the public, deciding in the that area.
You're a public spirited person. Go to the public interest litigation court.
But my lord, this matter on behalf of the state, my lord, my humble submission is that, my lord, I have come with the my lord report of the district inspector of schools and the, my lord, police authorities also, where from it is clearly, my lord, appearing that the some portion of the land is, my lord, he is, my lord, using, or my lord, he is illegally trying to grab the property. I have the, my lord, report of the DI as also the, my lord, police authorities. Therefore, my lord, there is a it's a duty. Therefore, my lord, yes, that is right. My lord, then, my lord, kindly
on the basis of complaint,
kindly convert it, my lord, kindly convert it to appeal.
My lord, may I submit, my lord? May I submit? This writ petitioner is, my lord, a name lender. I will show from the record of this Honorable High Court that this petitioner is filing one after another writ petition on behalf of the school. Now, my lord, one matter, this same writ petitioner, by suppressing his occupation and by suppressing his father's, whether his father is live or dead, has filed a writ petition, and that matter came before this honorable court and it has been dismissed for default. I'm carrying everything. This writ petition, I might not kindly appreciate, has annexed several documents of the school official records. How can an individual whose right has not, whose personal right has not been infringed, come before this honorable court by annexing some official documents of the school? Secondly, my lord, I am carrying judgments which I'll place subsequently. This writ petition, my lord, is not maintained.
Yes.
This court pass an order
My lord,
for placing this matter before the bench having the determination.
it's a matter. If your lordship sees that in any matter, according to my lord, my humble submission, I am submitting before your lordship. If there is any illegality and gross illegality and a portion of playground of the school, I have seen it, my lord. It is, my lord, 6th February 2024. I have received this, my lord, this report, my lord. Since then, this matter is not appearing. But this is a extreme urgent matter, and your lordship has to take some steps. If anybody, my lord, complains if there are any ingredients of, my lord, this type of.
I don't know why state is supporting
this This is the pace of the state.
What has state has done
State,
so long?
This is the thing.
Kindly come to Read rules.
This is the land given by the state to the individual school, to the school.
Patta holder. What is he saying? Without any research, he has come before this court. I am patta holder. Kindly seize my patta. And kindly also consider read rule 56, whether this person can maintain a writ petition on behalf of the school. Kindly consider read rule 56 of this Honorable High Court. Who can maintain a writ petition for this school? State, my lord, is supporting. I don't know why supporting.
Yes, that is why that land has been given by the state to the school for this
So
purpose.
for how long
for
the state
purpose
was
of.
keeping, my lord, I am also holding the land, my lord. Kindly see my patta. And my lord, kindly also consider read rule 56.
Take down. It was served in the year 24.
Immediately after filing of the writ petition, my lord. In fact, I've also mentioned, my lord, before this matter was listed, my lord, I had mentioned and I've served a notice on the on all the respondents again.
Where are those notices?
My lord, that had been handed up. No affidavit of service to that. Since they were mentioning notices, I've not.
Serve notice afresh. Serve notice upon the NHA.
If I may beseech your lordship only on one thing. If your lordship is pleased, even I do not mind, my lord, if it comes up after the vacation, but my lord fixes a time so that my lord, the matter can be heard out and disposed of. It's a very short point.
The affidavit of service is filed to the
My lord, my counterpart has.
No, Mr. Banerjee, Mr. Rai's case will be taken up. That is in item number 23, sir.
My lord, my lord.
The preliminary objection is there, my lord.
Let me place my case. But the affidavit of service, my lord. Wait, please, your lord. Lord, the petitioner and his wife, both are patta holders. And my lord, what happened? They are patta holders for 6 shatak of land.
They are patta holders?
For 6 shatak of land.
6 decimals.
6 decimals. Now, they were enjoying the property, and a small shop room was constructed for their livelihood. Thereafter, some local people, they were after the petitioners.
Yes.
And they created disturbance all through. Then, my lord, they came before the Honorable Court for a direction for unauthorized construction, for removal of unauthorized construction. Then, my lord, court says you approve, the allegation is vague.
The private respondents appear.
Private respondents.
They are the party here.
Here, no, my lord. Here, there is no private respondent.
But who is Samim Akhtar then?
Samim Akhtar was served, my lord. Samim Akhtar was served.
Who is that gentleman?
My lord, he is a local, my lord, leader of the, my lord, ruling party. He was there. Actually, he was after this land. And
Samim was served.
My lord, I have to check up because it's a long pending matter. I will not bother your lordship. Let me check up.
No, the service has not been affected.
We have served everybody in, but
no, so item bagged and item booked.
That was
Service
returned.
is not complete, sir.
It was returned.
But no, it is a matter under Land Reforms Act. Possibly, my lord, it will not lie here, my lord.
Let me place my case.
No, preliminary objections to be taken at the outset. I have learned that at the outset I have to take the preliminary objection. Otherwise, it is foregone.
May I then serve and come back?
Land Reforms and Tribunal.
No, my
And
lord.
yes, absolutely.
Specified act.
What?
Specified act.
My lord, what
What is the
innocuous,
point?
what innocuous prayer I have prayed?
Very good, sir. I'm not passing any order. The affidavit of service has filed.
Yeah. 27.
I'm filing my exception to the report filed by my learned friend in terms of the order passed by a coordinate friend. Going through the order impugned, Lordship, kindly give me just 2-3 minutes time, the brief facts of the case.
For the first time it is appearing.
No, there is a direction for filing report and exception also. Report has been filed by my learned friend. I have also filing my exception today. Under urban land.
আজকে ওই 4টের সময় স্পেশাল ফিক্স ম্যাটারটা আছে? Very good. Yes, sir.
Well, petitioner.
No, don't be anxious.
Just I'm trying. The petitioner's father Dharanidhar Dasgupta and uncle Muralidhar Dasgupta, both since deceased, purchased a plot of land with full construction of building measuring about 13 bigha and 3 katas in the year, my lord, 1959. Then 18th August 1971, a partition took place and the entire land has been described as 10A, 10B, 10C and 10D. The 10C and D has been given to the uncle and 10A and 10B to the petitioner's father. Then, my lord, a proceedings has been initiated after coming into force, Urban Land Ceiling Act, and show cause notice has been issued. Ultimately, my lord, draft statement has been filed. The legal heirs of the Muralidas, the other owner, filed an objection, and that objection has been taken out. And ultimately, if you also kindly come to page 72 of my writ petition. The order passed by Justice Devashish Korgupta as his lordship then was, so far the other property is concerned, the same property, block number C and D. The order passed by Justice Korgupta at page 70 and in
Just it cannot be taken up in a motion stage.
But only thing is that the direct
submitted an exception.
No.
Report, you have filed an exception.
No, what I am submitting, if you have to kindly go through the order passed by the coordinate bench. Coordinate bench directed to submit a report as to why there is a difference. Because in respect of property A and B, declaration has been given, there is no excess vacant land. And so far our property is concerned, same property, A and B, excess entire land has been shown by excess vacant land. Just see the order passed by Justice Rai. That will serve the purpose. Whether the report is acceptable or not. Kindly see the order passed by Justice.
No, I am not entering into the merit.
No, not only merit, just order by law dated 12th of November.
Page number?
12, in this matter. Coordinate bench first and order, Justice Ray. 12th November 2024. This is the only issue involved. Have you got the order? May I read, my lord?
Yes.
Affidavit service so Learned Counsel for the petitioner referring to a report dated 3rd of March 2009, prepared under the signature of the competent authority Kolkata, annexure P11 at page 72, to the writ petition submits that the similarly placed and adjacent to the land of the petitioners, which is the land of the uncle of the petitioners, has been assessed and declared that there is no excess vacant land. He then refers to another report dated 12th April 2023, attested by the competent authority Kolkata, shows that there is an excess vacant land in so far as the land of the petitioner is concerned and beyond the ceiling limit. In view of the above, the respondent number 6 is directed to depute a responsible officer from his office, who, upon a prior notice of at least 7 days to the petitioner, in presence of the petitioner and their duly authorized representative, shall cause a physical inspection of the subject land of the petitioner's is dispute. Kindly take note, petitioner's land. A joint inspection minute shall be drawn up, which shall have to be signed by the said respondent officer to be deputed by the respondent number 6 and the so and so. This exercise shall be carried out and completed by the respondent number 6 positively within a period of 5 weeks. The respondent number 6 shall file a report so and so, that needless to and so and so. Now, your lordship, kindly take up the report. Just take up the report submitted by my learned friend. What he did, the officer concerned again take measurement of all the lands, A, B, C, D. The court's direction why there is a discrepancy. You take measurement of the land of the writ petitioners.
Land of the parties.
No.
Were partitioned.
Yes, that has been partitioned. That has been declared there is no excess vacant land.
Partition by meets and bounds.
Meets and bounds.
By executed and registered deed of partition.
My lord.
By executed and registered deed of partition.
My lord. That is I have annexed.
Demarcating which portion is going to whom?
For me, CD for the uncle. So far CD is concerned, declaration is that there is no excess vacant land. So far AB is concerned, entire land has been declared as excess land. I came before this honorable.
At material time, the entire ABCD was taken into consideration or your land was taken into consideration?
So far the first measurement is concerned, only the land of the uncle was taken up because there was two separate proceedings. I filed a writ petition, my uncle's predecessor also filed the writ petition. So for their writ petition concerned, there is a direction to consider and take a decision. Inspection was conducted, it was found there is no excess vacant land. We filed a writ petition, same direction has been given. Again, measurement has been taken.
Sir, I have understood your content, sir. I intend to know at the time of the inspection, the unpartitioned land was taken into consideration while passing the adverse order, or your land was taken into consideration only?
At the time of passing adverse order, entire land has been taken note of. That's the report. That's the report.
And what is the next report then?
The first report only in respect of my land. I preferred appeal. Appeal court was the same. Appellate authority, statutory appellate authority, but held that this portion will not be given to the petitioner. Then I came before this honorable court.
Achha.
Because there is a tank. Our case is that only case, same land, character and nature is same, construction is same. You cannot take two different views.
Come on some other day. It cannot be taken up.
But kindly take the note.
Not have been.
Report. Only that my pair today, that they are fresh in a
It should not have been come under the heading motion.
I am suffering for last 20 years. Just take note of.
But for the first time, it has come before this court.
No, not first time, second time, because Justice Rai considered it. Your Lordship kindly
No,
take
no,
up
before
after
me.
vacation, fixed matter.
That
Mine.
fixed motion, adjourn motion.
Adjourn or not fixed.
Adjourn motion.
But adjourn motion will
Why?
because I shall only pay for a fixed another report. Because this report is contrary to the direction. Only this pair.
আজকে কিছু ফাইল করলো?
Yes.
The exception has filed on behalf.
Can it not fixed motion? Just a prayer. Because only thing possibly your Lordship after going through that will be directed to pass a submit a fresh report.
13 adjourn motion.
As your Lordship. Documents are very, but matter is not very big. As your Lordship.
Kindly permit me to mention item number 43. It is my duty. My lord, it is fixed at 4 p.m. Mr. Sharnal, learned senior advocate, my lord, he was supposed to make his submission before your lordship, my lord, today on behalf of the bank. My lord, he is on his leg before the honorable division bench in item in court number 11, my lord. That primary take matter.
I take matter, my lord. This is going on. After vacation,
No, let your other side come.
Other side is here.
My lord, Mr. Majumdar.
After vacation, no, I have heard it. I have heard it. It will be Mr. Majumdar. They are seeking an adjournment in your matter. Then tomorrow.
My lord, if it is tomorrow, my lord, subject to my lord's convenience, first half anytime, my lord, because 4 p.m., my lord, it will not be concluded, and Wednesday onwards, Mr. Sharnal is not there. My lord, it will take around 1.5 hours time, my lord. Some facts are.
I'm able to sit another 1.5 hour extra.
My lord,
You made me hard. And they are seeking adjournment after vacation.
My lord, kindly take it. First half, my lord, subject to my lord's convenience.
No. It will be given as it is and at 4 p.m. tomorrow then. How do you make these submissions?
Well, may we request for 3:30 then?
Very unfortunate. ওটা নোট টুডে করে রাখুন কি বড় বলুন তো 3:30 আর এতগুলো লোকের সমস্ত That is why I requested Mr. Majumdar that I will take up the matter after vacation. You would insisted me. Few days are left. When I will hear you, when I shall pronounce judgment.
Why many matter? Big matter, my lord.
Sir, every matter is urgent, sir.
We
Don't take that. That please, a primary matter is more urgent and this matter is less urgent. Tomorrow at 3:30 p.m. এটা লিখে রাখো তো on behalf $1.5 hours extra. No issue.
We are extremely grateful, my lord.
I don't have any grievance anybody.
I wholly appreciate, my
But
lord. What is
only
sorry for-
few days are left. When I will conclude and well, you know that I.
Have served all the parties. This matter is very short, Madam my lord. Person took loan from the
Which was the state?
Any day my lord fix that. Again, I can serve the notice pursuant to my lord direction.
They are not doing the mutation.
No, only man. Supreme Court is clearly covered by Supreme Court is clearly stated. The sale certificate is no need to for registration. Everything is completed. Only they are not. Everything is completed.
Sale certificate in a mortgage sale.
Mortgage sale.
By a court.
By a court. Special officer.
Huh?
Sale officer appointed by the banks according to provision of the statute. When any party fails to pay that mortgage loan, then sale officer to be appointed by the. He must be a government person.
What is the representation?
If you kindly, my lord, I'm drawing your attention to page 29, my lord. The assistant register categorically stated before the block land and land reform officer. May I read out the particular portion, my lord?
Have you made any representation?
Right to that, madam. At page 5, at page, my lord, 27. Appear before the my lord. May I be placed before the judgment, my lord? Categorically stated, my lord. Only suffering or not to mutate on the basis of the sale certificate. I have appeared before the authority. Illegally rejected, my lord, is a statutory
Hey,
violation.
bosu. Place your case.
My lord, statutory violation, my lord.
Where is the order? Which order is impugned?
This is the impugned order, my lord.
Which one?
Page 26 and 27. The ARCS also written, categorically written to the block and land officer. Insufficient of document, that means sales certificate has not been registered. The question of registration of sales certificate, not necessary, my lord, according to Supreme Court decision. Only order is insufficient.
Place the order.
My lord,
Place the order. Place the impugned order.
where it appears from the petition, Chandan Kumar Adar Sansata, that he has filed petition for recording the following scheduled land in name of such and such. I'm skipping, my lord. Next date, issue notice upon the interest parties, such and such. Next, notice duly served. Service return filed with the case record. The petitioner, both the parties are present on call. The petitioner, both the parties filed hajira, which are made part of the proceedings. Heard petitioners. The petitioner claimed that the land of Mirzapur, jail number 248, the applicant applied for the following schedule. Plot number 287, Khutiar number 451, share such 3334 such and such, a 10 decimal, will be recorded in his favor by virtue of the document examined. The documents produced by the examine the documents produced by the petitioner and the investigation report. It is found that the applicant has obtained the suit property by instrument of transfer of parties and succession of the following description, mode such and such, such and such. The claim both that does not make such file verification. Petitioner does not possess the plot. Document produced do not match with his claim. Other specified, not specified in hence rejected. The case is being rejected due to insufficient document. While a sale certificate produced.
So file appeal under section 54.
My lord, at page 29, I'm reading page. The assistant registrar, my lord, categorically stated. My lord, I'm reading from middle of the paragraph. The undersigned assistant registrar of cooperative societies
That the competent authority refused to grant mutation under section 50.
My lord.
There is an appellable order and appeal should lie under section 56.
My lord, but I came before your lordship. My lord, I came before your lordship. That straightway violation of the provision.
Very good. Let them violate.
The read code has
If I appear for the respondents for the Union of India in this matter.
Sorry.
For the respondent in this matter, respondent number 1.
Respondent state.
Union of India.
Who is the answering respondent, Mr. Dhar?
Railway as also the state, but mainly railway. Because
We represent the railway.
it was settled by the railway in favor of my predecessor. The property was settled by the railway authority at the time of CSR, at the time of the operation of CS settlement. And the nature of the tenancy was under Lakhe Rajdar, that is rent free. Kindly come to straight away to page 25. On top, my lord, on the left hand side, my lord has got Uporistoto Sotter Bharat Samrat. My lord has got it. Then, my lord, Otro Sotter Biboron o Dokolkar Eastern Railway Kotrik Porityakto B class Bhumi. Dong, my lord has got it. Dong. Kalu Mondol, such and such Mondol, Subejan Mondol, Pita such and such, Joed Mondol, Abir Mondol, then Pita such and such. And on the right hand side, Malad, kindly note this, Lakhe Rajdar. And Ongsho has been also mentioned. What are the total, against every Mondols, there are shares been mentioned. And on top, Malad, against Bharat Samrat, Malad will find Ek Ongsho. That is Akana, and that Akana has been shared amongst the Mondols.
Akana or Soloana?
Sorry, Soloana. I'm sorry. Soloana has been bifurcated, and on the right hand side is Lakhe Rajdar. That means rent free. So these are the tenants, and then the RS came in. And I have also annexed all the KB stage Khatians.
Led by anybody?
Yeah, Ravi Prasad Mukherjee.
Where is Mr. Mukherjee?
He's not come to court today for some personal difficulty.
Come
Your Lordship, we'll file our report in the form of the affidavit. And it can be taken after vacation, Your Lordship.
And I have some urgency because railway is going ahead with the construction. Later.
When it was filed? Sometimes in the March of 2024. Where is the service? Hey, Dago.
Your Lordship, it is taken up for the first time.
Service has been affected upon whom? Upon all the respondents.
My lord, upon all. Copy রেখেছো তো একটা বার করো না সবাইকে দিয়েছো তো item delivered.
Why you have made state respondent as a state as a party?
Otherwise RS CS RS are involved. That's why only.
What urgency is there, Mr. Dhar?
I have been paying the taxes and I have become the Rayat. As kindly come to page 35.
What type of construction is going on?
Railway is making the construction, permanent construction on my land.
What type of construction?
Laying the tracks on my land without any acquisition process.
Come tomorrow. Ask Mr. Mukherjee to remain present.
Okay.
The affidavit of services filed on behalf of
Lordship's indulgence.
अभी division bench, sir.
My lord, I know, my lord, extreme urgent. An application without certified copy is required to be granted leave. My lord, your lordship passed an order. My lord, I have, my lord, take out an application for recalling or modification of certain portion of the order because 8 kilometers road.
Come tomorrow, SSC.
Lordship.
My lord, with regard to item number 30, may it appear 1 week after vacation because there is a mistake in the writ application. The competent authority under the National Highway has not been made a party. My learned friend is Mr. Bandopadhyay is appearing on the other side. I can come with an application for addition of party in the meantime.
I don't know 39 लिखे रखो. As per 31.
No. 30, the very next matter.
As per